be with us from the Westin.
Mm-hmm. You want the art?
No. Oh,
Yeah, that's in my room too.
Yeah, I think the state had to pay extra for that. So
I think it's supposed to be like
good afternoon. Welcome to the House Judiciary Committee. It is February the 18th, 2021. And we have 8 bills with 55 witnesses. Unlike yesterday, which was more bills and 180 witnesses, so it might not take quite as long. We're going to start first with Delegate Conaway's bill, House Bill 959. And Delegate Conaway is the sole person to testify on this. So Delegate Conaway, if you'd like to begin and go for 3 minutes, great.
Thank you, Mr. Chairman and members of the committee. I'm Delegate Conaway, happy to bring this 959 to you. This bill was inspired by actually the vice chair, and I did a little bit of research, and I found out that you don't have to wait the 60 and 90 days to get a divorce. You can get a divorce in about 7 days. So what my bill does, it just adds something into the code to say, the court shall rule on an application for absolute divorce on the grounds of mutual consent under subsection A8 of this section, not more than 7 days after the date on which the application is filed. So if you two are in agreement, if you can come to agreement about property, alimony, child support in 7 days, they have to send your paperwork to you. Be glad to answer any questions you have, and I thank the vice chair so much for the inspiration. No questions? Well, with that, I would ask for—
I haven't asked them yet. If you have any questions, Delegate Conaway, we'll get there.
I'm so sorry.
The delegates, do any of you have any questions for Delegate Conaway? Delegate Cardin does not have a question, or he's just waving his arms. All right, great. Seeing no questions for Delegate Conaway, he's getting off easy. That concludes the testimony for House Bill 959.
Thank you, Mr. Chair.
Thank you. We're going to go now to Delegate Haynes. It's Delegate Haynes is the sole person to testify on House Bill 808, and he will get 3 minutes to testify on his bill. And whenever you're ready, Delegate Haynes, please go ahead.
Thank you very much, Mr. Chairman, Madam Vice Chair, and esteemed members of the Judiciary Committee. House Bill 808 is a bill that you've heard before. Actually, I filed this bill in 2017, I believe. And the bill basically addresses an issue in juvenile law under procedure, which does one simple thing. It allows juvenile hearings to be permitted, to permit appearance by video conference. This is a bill that actually came out of a task force looking at juvenile justice and juvenile justice issues years back. Like I said, it is a total reprint of the initially filed bill. And perhaps it was a little bit before its time in that the necessity of this type of hearing or permissible hearing was not fully contemplated. But I think as you look at the circumstances that we're in now with COVID-19, that it really is a bill now of its time. And it basically is not a mandate, it's not a requirement. It just actually provides for permission for a video conference, should that be an option that needs to be exercised on behalf of the defendant or of the prosecution. And if I can just add just very quickly, this is an outgrowth at the time the bill was initially drafted a few years back. Is because of the conditions with our juveniles sometimes have to travel. If they're from the Eastern Shore and they're placed in Western Maryland, they have to be transported for that particular point of time in shackles and et cetera. But I think with the technology that we have now, as I said before, and the conditions in which we are doing things, the bill is ripe for consideration again. I would request a favorable on House Bill 808. Thank you very much, Mr. Chairman.
Are there any questions for Delegate Haynes? Delegate Juanita Fisher, please.
Thank you, Mr. Chair. Hi, Delegate Haynes. So good to see you. I just wanted to ask, and thank you for this bill. I just maybe was a little confused. It's just some clarifying questions. So these are for juveniles for what specific proceedings? Like what type of hearings?
It is any hearing that actually is in current statute.
Okay.
Yeah, it would be for any, let me just pull the bill. Under section 3-8A-13F under the courts and judicial proceedings. So any hearings that is currently in statute, it would make it permissible to.
Permissible, and it would be on the defense's request. And then either the judge could grant the virtual hearing or not, or say.
Yes.
Okay, wonderful. Thank you, Thank you, Delegate Haynes. Thank you, Mr. Chair.
Thank you so much.
Delegate Cox.
Thank you, Mr. Chair, and thank you, Delegate, for you bringing this timely bill. I just wanted to quickly check on the language. It seems to limit to the child, and I noticed that in the statute, obviously, there's other parties. Would you be amenable to an amendment that would say something like interested parties may be permitted to appear by video?
Well, the reason why the bill is written the way that it is because, as you know, in criminal proceedings, so to speak, the driver proceedings, a lot of times, as far as the rights are concerned, is placed on the focus on the defendant. And this bill sort of follows that because juveniles have a right to counsel, they have a right to confer with counsel, they have a right to also appear in court and to be present in a court proceeding. And it should be the juvenile who makes that request as opposed to another party for want of perhaps granting something, the court granting something that is not consistent with the desire of the defendant. I would entertain it. I haven't, I'm not saying I would not entertain an amendment or discussing that issue, but that was the impetus of and the original thinking behind the bill.
Excellent. Okay. Thank you, Delegate.
Mm-hmm.
Further questions for Delegate Haynes? Seeing none, we thank you very much. And that concludes the testimony on House Bill 808.
Thank you, Mr. Chairman and judiciary members. Thank you so much.
Thank you. We're going to go to House Bill 816, Delegate Shoemaker, simple country lawyer, here with us today for House Bill 816.
Thank you very much.
It is you, and there's one person to testify in opposition. So we'll give you 3 minutes. Go right ahead.
Thank you, Mr. Chairman. You know, a couple of years ago, the legislature repealed the requirement that children support their adult children, support their parents, because it was a statute that was rarely utilized. However, as we sit here today, the legal obligation that parents support their adult children remains, even though, as the fiscal note reflects, that too is a statute that is rarely used. And that seems incongruous to me. Some of you, may have heard that my mom passed away last week. I can tell you that she supported a relative. I'll leave it at that. who certainly could have worked, and she supported him for his entire adult life. She felt a moral obligation to do that. The legislature, in my opinion, however, should not legislate morality to the extent it can avoid doing so. This particular issue was brought to my attention by a constituent of mine who was brought to court by his adult daughter in Baltimore County. And the judge in the Baltimore County case felt constrained by virtue of the law that's on the books presently to award his adult daughter support from her father using the Maryland Child Support Guidelines. And I think some of the language that the court used, though, in fashioning the decision in that case is, illustrative of why it is that I brought this bill on that particular constituent's behalf. The judge said, the judge was constrained by the law and awarded this adult child support using the Maryland Child Support Guidelines, because that's all they had to work with was the Maryland Child Support Guidelines. But the judge said in issuing her decision in Baltimore County, quote, "To have parents supporting an adult in this fashion is a very unusual situation. And I do believe it hinges," I think she meant infringes, but it was transcribed hinges, "upon the liberty and freedom of parents. Just as parents are required to support children, minor children, there does come a point in time where a child is entitled to make their own decisions, and an adult is entitled to be free of the obligation of supporting that person."
Delegate Shoemaker, if you would wrap up your comments, we'd appreciate it.
And the judge went on to say it's not a life sentence. So, but being constrained by the law, the judge found for the adult child and assessed child support against my constituent, and that's why I brought this bill.
Okay,
Thank you, Mr. Chairman.
you're welcome. Are there questions for Delegate Shoemaker? Delegate Grammer first, then Delegate McComas. Delegate Grammer.
Thank you, Mr. Chair. So how old was the child?
In this particular case that I just referred to, in their 30s.
In her 30s.
Yep.
Help me understand how the child support guidelines would guide a judge to allocate, these funds. I've never understood. I've never understood this to be what these are for.
Well, I guess that's the only vehicle the judge felt that she could use to determine what, if any, support to provide to this adult child. So they used the child's income and the mother's income, because the parents were divorced. They factored in the child's income, which I think was 0, the mother's income, which was like 22% of the total household income for purposes of calculating the guidelines. And my constituents was like 78%. They plugged the numbers in and they assessed him with like a $400 and some a month adult child support obligation.
Is this the only, have you seen any other examples of this?
I've never seen this before, Delegate.
And the living conditions of the child, like destitute, this doesn't mean like the child has a disability or they're, temporarily disabled.
The judge found that.
Destitute has a big, I can't pay my bills right now.
Yeah.
Some days I'm destitute. Define destitute in this particular case.
Yeah, well, it's kind of hard to define what destitute means, particularly within the context of the law that's on the books now. I can tell you that the judge thought that this particular adult child could work and could obtain gainful employment. But she felt constrained under the law as it exists presently to award support using the Maryland Child Support Guidelines.
Do you know the history of the statute? I mean, I get a general sense of what it's trying to do, but do you know why it's here? Why
I
it was
have
put in?
no idea. I have no idea. I suspect, I mean, I suspect it's been on the books a long time, just like that law that we repealed a few years ago about supporting your parents.
Okay, I appreciate the answers.
But,
Thank you, Mr.
but
Chair.
in the fiscal note, the fiscal note writers say it is rarely used, but in this case it was.
Delegate McComas?
Thank you, Mr. Chair. Delegate Shoemaker, you have the redheaded Eskimo case here. In other words, it's just so unique. Mike, and no offense to Eskimos, it's just, it's a
Yeah, I know. I
legislative
jargon.
banter. Anyway, my question is, the statutes for child support guidelines, is there anything in the statute that says you can use that for dealing with a destitute child? I'm just wondering if the judge kind of, because it's statutory. And I've always said the judges won't do anything unless it's in the statute, if it's a statutory situation, like domestic violence. If it wasn't in the law, they wouldn't do it. And so that's why that law kept getting amended. And I'm just kind of like wondering how the heck did the judge feel they had to use that? I mean, she could have used something else. She could have just had the destitute child's budget and the husband's budget and the wife's budget and just kind of figure out a way that might be fair.
Yeah, Delegate McComas, I think that was the only. I think that was the only vehicle she had. I'm happy. I think you all have a copy of the decision in that case, but I'm happy to get you a copy to make sure you have it, so you can see.
Well, okay.
I did that.
Well, I just, but she could have fashioned, Delegate Shoemaker, could she not have fashioned something different than the guidelines?
Well, I mean, I think she did. I don't believe she was constrained to use the guidelines. I just think that was the best tool that she thought she had at her disposal. I think that's what happened. I mean, it's she was sitting in equity. So, I mean, I guess she could have fashioned some kind of equitable remedy, but that's what she chose to do in that case.
Well,
involved in that litigation, by the way. So,
okay. Yeah.
I can tell you that, I mean, the obligor in this case is a constituent of mine from Westminster, and he provided me with a copy of the transcript of the decision, and I can get you a copy of that so you can see what she said.
Just another quick follow-up question. Was there any alcohol or drugs involved that's why this person couldn't, make a decent income, or was there any disability that they were, that they couldn't work full time?
Well, I mean, there are references to the fact that there had been some kind of underlying disability at one point. I think they had the Department of Rehabilitation Services do an evaluation or whatever. But the judge says that, the adult child in this case made a very impressive witness and was coherent and articulate, and she didn't see any reason why this young lady wouldn't be able to secure gainful employment. So that was interesting.
Thank you, Delegate Shoemaker.
Vice Chair.
Thank you, Mr. Chair. Hello, Delegate Shoemaker.
How are you, Madam Vice Chair?
I am good. Good to see you. So I wasn't going to say anything, but so the question was asked by Delegate Grammer, what constitutes a destitute child? So we can all open up the statute, and the statute says, not only does the child have no mean of substance, but they cannot be self-supporting due to mental or physical infirmity. So for that is the reason why the folks at the Maryland Developmental Disabilities Council, the ARC of Maryland, and the Disabilities Rights of Maryland came out against this bill. So if we repeal this piece of legislation, essentially what we're doing is saying that parents don't have to take care of their adult disabled children. And then we are essentially throwing them out and saying, hopefully, take care of yourself. Folks who probably can't live by themselves, can't physically take care of themselves. I mean, that's what we would be doing. Isn't that so? That was actually really rhetorical. So,
Yeah.
And then my last thing is, I understand and I do appreciate the fact that when you come before us, you do bring constituent concerns, which I do think is fantastic. You're in touch with your constituents. But I don't know, we weren't in the courtroom with you. We don't know how that individual presented themselves. We don't know the judge's findings. We're hearing your side, and you obviously presented one side of the case. So I don't know that it's fair for us to judge what happened in that courtroom and who saw what. Isn't that so? And that was also super rhetorical.
It was very rhetorical, but I
But in any event, it's good to see you. You guys got a lot of snow in your county when I was leaving Howard County this morning. It looked like a mini blizzard was happening out there.
Yeah, we had about 5 inches on the ground on my street as I was pulling out this morning. So, and it was still coming down.
I'm glad you made it here safely.
Thank you.
Now with, to finish up weather and traffic on the fives, we're going to Delegate Conaway.
Thank you,
Delegate,
Mr. Chairman. Thank you, committee. Thank you, delegate, for presenting this bill. So you said that the adult child had zero income. And I was wondering if the adult child who's disabled had zero income, why couldn't the child apply for welfare or social services? Why couldn't an adult apply for welfare or social services?
I think they could have. I think she could have. But in this particular case, she chose to, sue her father for support. And it wound its way through the Circuit Court for Baltimore County, and they issued the decision that I referenced in my opening. And the judge said, "Hey, I'm constrained by the law as it exists presently." And
So she
I
had,
think she very, very well could have availed herself of governmental programs or whatever.
so she had legal counsel representing
She
her?
sure did.
All righty, thank you.
Delegate Cox.
Thank you, Mr. Chair. Good to see you, Delegate Shoemaker. Thanks for being
My
here today.
pleasure.
Great
My
bill.
pleasure.
Great bill, trying to work on a constituent issue like you normally do, and my hat's off to you. And I just wanted to look at the fiscal note real quick, and I happened to read over and I noticed there's no fiscal impact. That's a good thing. And they went on to say that, I think to echo what you were saying, that this bill is, this statute is so rarely used that the judiciary couldn't find anybody that's being in any way impacted by this bill on either parole or probation. And Baltimore City indicated they haven't had an incarceration for 13 years on this particular statute. And then the MDH, Maryland Department of Health, indicated that a lot of these individuals probably will be on Medicaid anyway, so it's not really a known factor of any kind of impact.
Yeah, and just
Your
to,
understanding?
yeah, exactly, Delegate Cox. And just to follow up, I mean, that was the same rationale that we used just a couple of years ago to repeal the obligation that was on the books that children had to, adult children had to support their parents because nobody had been prosecuted on that under that particular statute for like 80 years. So yeah, it's kind of the same rationale. It's just the flip side.
Excellent. Thanks so much.
Thank you.
All right. Are there any further questions for Delegate Shoemaker? Seeing none, thank you, Delegate, for being here
Thank you.
today. And that concludes the testimony for House Bill 816.
Thank you, Mr. Chairman.
Thank you. All right, the next bill is the Vice Chair's. It's House Bill 748. There are, do we want to just hear everybody at once? Yeah, let's go ahead, except for the unfavorable. So we'll hear from Delegate Atterbury and then Paul Griffin. Oh, wait a minute. I'm wrong about something. There is actually a person opposed, I think, to House Bill. Yes. Is Michelle Smith available? Because we didn't, I forgot that. Sorry. Michelle Smith was here to testify in opposition to House Bill 816. So let's get her in and give her 2 minutes to talk. We can't go. She is coming in. There is Michelle's iPad. Michelle Smith. Ms. Smith. Yes. Is Michelle Smith available?
Hi.
Hi, there she is. Okay. You have to turn off the YouTube feed. And when you're ready, you get 2 minutes.
Thank you, Mr. Chair. I was
All right.
frantically waving. I'm sure you saw me.
Yeah, sorry about that. Oh, you have to turn off your other, you got it?
Can you hear me now?
Yes, for
I
House
was
Bill.
trying, it's an interesting logistics now because you have to listen I rarely oppose things, but I'm here opposing. So I was listening to the commentary and I think I could help clear up a few issues.
That's great. Go ahead. You have 2 minutes.
Thank you, Mr. Chairman and Madam Vice Chair for chiming in with the law. And Sponsor Shoemaker, I do understand why you've proposed this bill and my condolences on the passing of your mother. Members of the committee, I'm here. I'm Michelle Smith on behalf of the Family and Juvenile Law Section Council of the Maryland State Bar Association. I'm just going to get right into the nitty gritty of it just to clear up a couple of things. We do urge an unfavorable report for House Bill 816. First of all, you heard the definition of a destitute child. I also wanted to point out in the statute that the parent who is failing to supply necessary care, and it's really defined very clearly, food, shelter, care, and clothing for a destitute child. So that's a child that cannot be self-supporting due to mental or physical infirmity. I'm using child, but this really is an adult. The law still sees it as a child. Those are the kinds of things the parent is supposed to be supplying for that adult destitute child. And it's only if that parent is able to earn means sufficient to provide those things, those necessary things for the child. Also, in a separate section, it talks about determining the amount of support. The court shall consider the financial circumstances of the individual. So there's no requirement to use the guidelines. The court can use absolutely any financial information that it finds relevant on this issue. So we ask you not to repeal this because in the family law context, we use this statute. I'm not talking about the state's attorney prosecuting people for criminal behavior. I'm talking about in the family law context, when we have adult destitute children, we ask the court to have the parent continue to provide the necessary food, shelter, and care for that child so they do not become a charge of the state. And so we are using it. it may be rarely used in the criminal context at this point in our law, but we are using it, and we feel that if it's repealed, this statute is repealed, adult destitute children are going to have a very hard time continuing to have support from their parent. So we urge an unfavorable report for this House Bill 816.
Okay. Does anybody have any questions for Ms. Smith? Delegate McComas.
Thank you, Mr. Chair. Ms. Smith, I just have some questions as to how this works. If the child is physically or mentally destitute and unable to work, okay, and so would they then, I mean, because you're dealing with Social Security disability benefits possibly that they could get. And then if you say, okay, well, that's not enough, we want the parents to pay, or the parent, would that, okay, let's say they get the Social Security disability benefits. And then if they get more money from their parents because they're destitute, is that going to trigger some problems with the disability benefits? In other words, there's got to be a coordination. So you're not taking away what they've gotten from one thing and hurt the other. So I just kind of wondered how that balance works.
There's another section to the statute, Delegate McComas, that talks about the court has the authority to order the support be paid either to the individual destitute adult child or to the agency that is authorized to receive the payments. So there can be a coordination. The statute does speak to that.
Well, what I was not, actually, it's not necessarily coordination of the benefits, but that you would be reducing benefits either from the parent or from the Social Security Administration.
Yes, I think the judge would consider all of those factors when fashioning a support order.
Right. And of course, if they get SSI, they would then get Medicaid. So they would have insurance, right?
I can't answer
Well,
that. I'm sorry.
okay.
Yeah,
All
it's
right.
not my
Right.
field of expertise.
Okay, thank you.
Thank you.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Ms. Smith, for coming in. I would like to approach this from a little different perspective. Let's say a person is a millionaire and they have an adult destitute child, and they say, I'm going to put my child on social services or some welfare when they're 30 or 40. You're saying like the court could come in and say, no, you have $1 million and therefore you have to finish supporting your child, even though the child is adult, because you have
Yes.
to do
If
that.
the child qualifies as a destitute adult child. So that means they have to have a provable mental or physical infirmity that causes them not to be able to be self-supporting.
Thank you so very much.
You're welcome. Thank you.
Are there any other questions for Ms. Smith? Seeing none, thank you very much. You can stay right there, Ms. Smith. We could go
Thank you.
ahead and call everybody on the next bill. This is the Vice Chair's bill. So now, House Bill 748. We will hear from Paul Griffin, Michelle Smith, Dorothy Lenig, Lisa Jordan, I think had to go to appropriations, and Lori Ruth. But before we do that, we are all waiting. It may happen today. It may happen next week. It's hard to say. But we will all be waiting for our newest delegate, Delegate Rachel Jones, to be asking her first question. And I don't want to put too much pressure on her, but it's a big deal. So, don't overthink it, but we're all going to be harshly judging you based on what your first question is going to be. Welcome to the Judiciary Committee, Delegate Rachel Jones. Thank you very much for joining.
Thank you. Glad to be a part of the committee. Thank you.
All right. Thank you very much. And Delegate Bartlett has indicated in the chat something that is absolutely false. All right. We're going to now go to the Vice Chair's bill, House Bill 748. Delegate Atterbury for 3 minutes, please.
Thank you, Mr. Chair and members of the committee. Good afternoon. I am Vice Chair Atterbury, and I will be asking for a favorable report on House Bill 748. This piece of legislation is a product of a work group that was created in 2019. It's comprised of a lot of experts, far more than I, who served on it, that you are hearing from someone. Paul, yeah, there you go. Okay, that ate into my time. You'll be hearing from them. I will say from the outset, Senator Lee has some amendments to her bill that she accepted. I'm accepting the same amendments, so I'll discuss that in a second. But Delegate Jazz Lewis and I served on the work group. And the work group was charged with taking a look at a couple of things. But for our purpose in this bill, the work group took a look at child custody in the court process here in Maryland when there's been allegations of domestic or child abuse. And so as amended, which you don't have the amendments, Lauren was gracious enough, thank you, and has already drafted the amendment. So I do have them for the committee. So as amended, the bill does a couple of things. It takes out the best interest factors, which if you've taken a look at the bill, you'll see in the bill. It says now that a reasonable effort to protect a child during visitation or preventing a visitation based on a belief of child abuse or sexual abuse will not be deemed by the court as an unjustifiable denial of visitation, which is not the case now. The second thing that it does is it says, before you consider the best interest factors, which we'll be hearing Delegate Dumais' bill later, you've heard multiple times, before you consider the best interest factors, which now is based on case law, the court has to take into consideration any domestic violence and child abuse allegations. And then finally, of note is that the court will have to make specific findings related to those allegations, whether or not they're founded or unfounded, and have to actually articulate them in a decision. And you'll hear the reason why this is important is because it's not being done uniformly across the state at this time. So I just want to reiterate, I think I had a chance to reach out to all of the experts that are following me. I have accepted all the amendments that Senator Lee and you all worked out across the street. So thank you for being here. Thank you, Mr. Chairman. You're on mute again. We've just been doing this since March, but you know.
I unmuted myself and somebody was quick off the trigger to mute me again. I think it's a subtle hint. 2 minutes now for Paul Griffin, please.
Thank you, Mr. Chair. I appreciate your time. I'm sorry about the audio issues earlier. My name is Paul Griffin. I'm the legal director of Child Justice. Child Justice is an organization in Maryland that litigates child custody cases involving domestic violence, child abuse, including child sexual abuse. I was also a member of the work group that Vice Chair Atterbury was a member of. And that work group met for almost 2 years, heard from copious witnesses that we brought in from around the nation, not just Maryland, but experts in the field throughout the United States. And it was the consensus of the work group that some of these recommendations be recommended to the legislature to be added into law. And that would include this bill, 748, and its counterpart, Senate Bill 57. As Delegate Atterbury pointed out, this really accomplishes 3 things that we're trying to have done here. It requires judges to articulate the best interests of the child factors before making their decisions. They have to articulate on the record what it is they're doing and why they're doing it. Often they will not go through the standards when they make their findings. They may cite 1 or 2, but not all of them. It also points out that the hierarchy here would be Family Law Article 9-101 and 9-101.1 Am I muted? Am I working? Okay, I'm sorry. I got a sign that I was muted. That they go through those factors of abuse and analyze them first as distinct factors from the other best interest of the child factors. And it also articulates that if a party has a reasonable fear of imminent abuse, a parent enacts on that, and it's well, assuming it's reasonable, of course, that is a valid and legal excuse for them to otherwise violate a custody order and cannot be used against them when determining custody in other modification hearings. That's important because we will often see what's called the friendly parent provision. How much is a party encouraging relationship with the other party as a factor in custody cases, and it's used sometimes to the exclusion of a parent who is reasonably taking acts to protect the child from abuse. We believe if a party is acting reasonably, even if ultimately the abuse is not proven, but if their actions are reasonable, that should not be used against them in a custody proceeding. We hope that this committee will vote favorably on 748, and their colleagues across the street will do the same on 857, and they were able to enact these provisions of the law. And I'm available to answer any questions if you have.
Thank you very much, Mr.
Thank you. Thank you, sir.
Now for 2 minutes, we'll go back to Michelle Smith. 2 minutes, please.
Thank you, Mr. Chairman, and hello, Vice Chair Atterbury. Thank you for sponsoring this piece of legislation. Committee members, again, I'm Michelle Smith here on behalf of the Family and Juvenile Law Section Council of the Maryland State Bar Association. The Section Council urges a favorable report for this House Bill 748 with amendments. We do acknowledge the issue of abuse in custody matters is extremely complicated. We all try these cases routinely. It's, I believe, some of the most difficult work that judges do. It is not always adequately addressed at the trial level, and we support the efforts to improve the process through this bill. Some of the amendments that the sponsor, Vice Chair Atterbury, has already gone through with regard to the same ones in Senate Bill 57. We fully support, and we assume that those will be added. We had a couple of other issues we would like to bring to bear, and that is the section that you all have been speaking about already. The Vice Chair spoke about it, as well as the first witness, which gives a friendly parent the right to withhold the child upon any reasonable effort to protect that child, or a party for that matter, from the other party. We do have some concerns that there might be detrimental unintended consequences in that we see, unfortunately, sometimes parents using this type of broad language to hurt the other parent where the other parent isn't actually doing anything harmful. And we find in our practice on the Section Council that it's better to use a protective order or emergency hearings where there's a judicial officer weighing factors and weighing evidence, where there's an ability to cross-examine witness and present your own case in a defense if you're that parent that's being charged with harming the other child. If one party is withholding a child in contradiction to a standing custody order, that's a pretty big deal. So we do express some caution about that particular section. Thank you, Mr. Chair.
Thank you very much. We can go now to Dorothy Lenig, please, for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Dorothy Lenig. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. The House of Ruth serves victims of domestic violence throughout the state. I want to start by welcoming Delegate Jones to the committee. It's nice to see you. I don't want to repeat anything anybody has said. I want to thank the Vice Chair for introducing this bill and the amendments. I think the amendments make it a better bill. The part that I wanted to emphasize was so many people in family law cases are unrepresented. According to the judiciary in FY18, 81% of family law cases, at least one party is unrepresented. And in Prince George's County, it's 93%. So this bill in various places requires the court to spell out its thinking. And I think that's really important. Court goes very quickly sometimes. There's a lot of legalese. And if you're unrepresented and you walk out of court and you don't really understand why the judge gave somebody custody or why the judge made the decision that he or she did, it can be really confusing and leave a bad taste in the litigant's mouth. So for this bill and for HB 505, I think it's important to remember how many people are unrepresented. Thank you.
Thank you very much. We'll go now to Lori Ruth for 2 minutes.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. I want to thank Delegate Atterbury for bringing this bill and for discussing the amendments. I was also on the work group with Mr. Griffin and many others, and I just want to say at the outset, it was a very interesting group of people. There were not that many lawyers on the committee, not that many people with sort of boots on the ground courtroom experience, but everybody was extremely well-intentioned, and we learned a lot, I think, from each other. The amendments that have been discussed are, I think, a terrific improvement on the original bill. And I want to thank Senator Lee's staff for meeting with me and Rebecca Fleming, the current chair of the Family Law Section Council. That's where these amendments came from. And they really fixed some of the problems we had when we testified on the Senate side. I just want to agree with Ms. Smith about the broad language of the 9105. And stress that that was one issue that we could not reach agreement, that language, we could not reach agreement with Senator Lee's staff about trying to tighten it some so that it wouldn't be such broad language. And, you know, we thought about it and we just couldn't come up with a fix for it. So we do have the same concerns that Ms. Smith mentioned. And other than that, I think that it has now become a bill that really is framed from the work group's mission directly to what we were supposed to address in that work group. And we urge a favorable report with amendments. Thank you.
Delegate Arakan.
Thanks, Mr. Chair. I'm so excited about this bill. I really love it. And I'm so glad that you guys worked so hard on this for the last 2 years, because it's really important work. Can anybody be more specific about the actual language of the amendments? I mean, I would love it. Could we get it emailed to us or something? Could somebody touch on the actual language and how many there are, what specific things to
well, Delegate Atterbury has the language. I'm sure she can send it to you all. But you know, when you read amendment language, you really have to sit next to the bill and sort of cross things out and add things in. So I can't, you know, it's a little hard for me to tell you. They removed almost all of page 3 and on of 9109. So that's the biggest and most obvious change. Okay. And it's, you know, it starts at the bottom of page 3 at 9109, and it X's out lines 29 and 30 and adds in language that I think speaks to the hierarchy that Mr. Griffin was discussing, because it says, in any custody or visitation proceeding that involves a domestic violence or child abuse allegation, the court shall refer to sections 9101 and 9101.1 of the subtitle before considering any factors relating to the best interest of the child. So it's creating essentially what Mr. Griffin called a hierarchy of factors. What I discussed with Ms. Fleming and Mr. Laurie when we were discussing amendments was sort of a threshold finding by the court, so that it would ask the court if there are allegations that come out in testimony about domestic violence or child abuse. They're going to take the whole case 1 day, 2 days, however, they're going to listen to all 20 factors that each side might bring up about what's in the best interest of the child. But if there are allegations of domestic violence or child abuse, they first have to address that under 9101 and 9101.1. Because I think the feeling when Delegate Atterbury said it's applied unevenly in the state, I think anecdotally, and I think Ms. Smith would agree with me, that we hear that most judges just disregard it. They're not even addressing it. And judges or magistrates, say judicial officers, the court. And so the effort, I think, with the amendments is to prioritize that issue and make the court articulate what its finding is before it moves on to look at, where they go to school and who has a bedroom for them and all the other factors that are considered under the case law. So that, to me, this new language that strikes almost all of 9109, starting at the bottom of 3, really articulates what the work group wants to happen. And I hope Ms. Smith and Mr. Griffin particularly agree that characterization is accurate.
Okay, good. So it's not watering it. It's not watering it down. My fear is right. It's not just that they're uneven. It's that if a woman says that she's been abused, she's more likely to be penalized for saying that. So,
well, and that is definitely some of the, that is, excuse me for interrupting. That is definitely some of the presentations that we heard in the work group were of that nature. That sometimes the protective parent, which is what 9105 speaks to, is penalized or punished for trying to protect their child. And the effort in that section is to protect the protective parent, or the friendly parent, I think, as Ms. Smith referred. And so this is not a watering down at all, but I think it was an acknowledgement that HB 505 that you're going to hear about in a few minutes, hopefully, is a better articulation of the best interest of the child case law being put into statute, and that the original rendition of this bill was sort of overbroad to the work group's work. And so it's not a watering down, it's really a focusing, I would say, of what the work group was really trying to get at. And I think the amendments really, really do that.
Okay, awesome. Thank you all.
I could offer something more, Delegate Arakan, too, just to clarify. And it's really just a clarifying point. I agree with everything Ms. Ruth just said. But the section that she read to you is in addition to a new section, new language later on in the statute that says that in any custody or visitation proceeding at all, in determining the best interest of the child, the court shall articulate its findings of fact on the record and any factor the court considers. That strengthens that section as well, because it wasn't as detailed as that before. And I could also just add one other thing to the vice chair. I would love it if it said in there, or the section counsel, not me personally, would like it to say orally or in a written opinion that they stated on the record, because, in real life, judges say things from the bench and then they follow it up with a written opinion. And so we need to capture that they're going to do it in both. Thank you.
Okay, thank you very much.
If I could weigh in, I agree with everything my friend and former colleague Lori Ruth said about what these amendments do. They're not watering down. They're focusing, and it is striking some stuff that's going to be addressed in another bill. I think 505 in front of you all.
Okay, wonderful. Thanks for all the hard work.
Thank you. Thank you.
Going now to Delegate Deborah Davis, please.
Thank you, Mr. Chair. I have lots and lots and lots of questions, and I'd like to view it. I'd like to view the bill again with all the amendments. But to start, so have we removed the friendly parent wording? Have we removed the best interest of the child? And what about unintended consequences to diverse communities? I mean, it really, we'll have to sit down with it, but I've got so many questions. If you could start, I'd appreciate it.
So I'll just say first, and then someone else can jump in. In terms of, so we took out all the best interest factors, and so you'll hear another bill coming up later. And as you know, the courts right now use case law in determining what's in the best interest of the child. But that language we took out of this bill. What your second question was? What was your second question?
Did we take out the friendly parent was another question. And how does it affect minority families, I think was I don't know where she went. So I don't speak for her. I'm still trying to be helpful. Yeah.
I'm still here. I said diverse communities.
Yes.
Well, I think, the focus of the work group didn't have a focus at looking at different communities in terms of their race and ethnicity. The work group was specifically tasked with looking at cases where sexual abuse and domestic violence, which affect all communities, are in custody proceedings. And what was actually striking to me is what Delegate Erican already said, and it was shown to us in statistics, that when allegations are made, particularly by a woman, regardless of your color, you're generally not believed. And then that child is often given to the other parent who just goes to right back to abusing the child. I mean, the statistics were staggering, quite frankly. So that was the task of the work group.
I'm looking forward to an opportunity to talk about it.
If I could just add, I think one of the most important things, Delegate Davis, is that people will come out away from the case knowing what the judge ruled. Because as you know, people are unrepresented in court. And so I think it helps everybody to be able to be clear that the judge, it isn't just in the judge's head, it's also going to provide clarity to the litigants. On the friendly parent provision, there's language added, but I think Ms. Smith talked about, you all should take a good hard look at that piece and think about it. The rest of it, I think, really does just clarify that the judge needs to make a finding on the record. Either you can add orally or in writing or whatever you want to do, but it would make it that when we did the listening sessions on the previous custody commission, so much of what we heard was that people walked out of court and they didn't understand why the judge decided what he or she did. That was where so much of the bad feeling came from. And this bill and House Bill 505, I think, would clarify that for people.
If I could add one thing to what Vice Chair Atterbury said and to Delegate Erican said earlier, we had some facts put in front of us, some statistics put in front of us that even, particularly if it was a woman, a mother, would raise allegations of either domestic violence or child abuse, even when the court agreed with her and made a finding that there was in fact abuse, the percentage of at least joint custody, if not sole custody, given to the abuser was astounding. We have one case right now, I won't say what county it's in, but we were involved with it. We twice, the same judge on the same issue, 911 they were dealing with, we had got him reversed twice for failure to take into account 9101 and his findings. Even if the court special appeals remanded it back to him and ordered it, it still didn't happen. And we went back to the appellate court and reversed it. But it's been 2 years since that case was brought to trial. And we still don't have the protections in place for that child, even though the law provides for it, the current law. And these changes here still, unfortunately, I don't know if they'll address that. Nothing legislature can do when a judge just will not follow the law. That's up to the court system to deal with. But it just shows you how frustrating it is for parents and for lawyers when the court is not following these procedures and these protections that are put in place.
Right, I should say Lisa Jordan did in fact sign up for this bill. She was taken to appropriations and now she's back here with us. I'm going to go ahead, if she's on the line, we'll give her her opportunities to speak for 2 minutes and then we'll take Delegate McComas's question. Lisa Jordan, are you there?
I am. Thank you, Mr. Chairman, Madam Vice Chair. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 748 with the sponsor amendments that have been discussed. The Sexual Assault Legal Institute is part of our agency, and so we provide direct representation to survivors of child sexual abuse and adult abuse, but all across the state. And what I would have said has already been said by others. So I will just say that I agree with that. I do urge a favorable report. I appreciate Delegate Davis's questions about disparate impact. I would note that from our point of view, we think that this bill will actually help litigants who do not have representation, help litigants who are not operating in the SINA system. I think it's an important thing for communities all across the state, and would be happy to talk about that more. But I will defer to the other witnesses. Thank you.
Thank you. We're going to go back now to the question from Delegate McComas, please. You muted yourself.
Okay, thank you, Mr. Chair. The question is, I have a couple questions, but for Mr. Griffin, in the case you were referencing where it's kind of like Groundhog Day,
yes.
was there an attorney appointed for the child to represent the child's interests or the children's interests?
I'm trying to think, because we came in on the appeal. I
Okay.
believe there was, but I can't say for sure.
Okay. The other question I have is that what could someone give me a definition of what the reasonable that abuse occurred? And is that standard going to be preponderance of the evidence or clear and convincing evidence, or is there going to have to be domestic violence petitions that were filed and that were granted? In other words, I kind of want to know how far this is, or it's just kind of between it happened and a suspicion it might have happened.
Sure,
You're jumping ahead of the factors, what's in the, you know, the statutory, or not statutory, but the case law factors of what's in the best interest of the child. So kind of like, how's that going to work?
I can address if others would like. When coming up with the language in this bill, we did debate about putting factors in there, but we felt that it was best to allow the courts to develop, allow the judges to determine what they believe to be reasonable. And that is giving them a lot of discretion, but that is what we do with judges. We give them discretion to make that determination. I think if it's going to be what a reasonable belief is of a person, I'm not sure that you put an evidentiary standard in there. If a parent reasonably believed there was abuse, the court would listen to what they have to say and make determinations. Obviously, if the parent says, I had a dream that my son was abused, therefore I did all these facts, I don't think a court would find that to be a reasonable belief. But if they said, well, my son told me this and I had evidence with a bruise, I certainly think most courts would consider that to be reasonable, even if they ultimately determined, I don't think this happened. I think that the child evidence from school as he fell down on the playground, that's where the bruise came from. But at the time, that's not what the mother knew or what the parent knew, the protective parent. I don't believe that a court should have to look at whether protective orders were granted or not granted. I think some parents will, and to tell you the truth, I've had it where even in instances where parents just went and sought protective orders, particularly if they lost, that has been used against them by the courts. The courts, the custody judge will see that as a type of forum shopping. You went to some other judge to get protection in the middle of the night, or to the district court, to the circuit court, or the fact you lived in another county than where this case is now being heard. You went to that county. I find you be forum shopping, and I'm going to use that against you. They're not going to say it, articulate it quite that way. So I would be hesitant to require them to get a protective order. I'd be very hesitant to require them to get a protective order because some parents are very scared to do that for the reasons I just stated.
Okay, the other question I have is the follow-up is that by jumping ahead allegations of abuse, sexual or physical, to either the parent or the child, is that going to incentivize people from just merely saying it? Because at the end of the day, child support, it's all about money can fuel some of this stuff. And so I'm kind of worried about that as to, some people are very good in front of a judge and others aren't. And manipulation does happen. So that's why I'm kind of concerned about what's reasonable. And the fact that you're kind of jumping ahead of those factors, which have been at play for a long time. So just thoughts on that.
I would say that there's a widely held belief, and I'll use mothers again, that they use abuse and domestic violence and child abuse to game the system. The experts we brought in, and I certainly know anecdotally, I think that those beliefs are not well founded on the whole. I mean, sure, people lie in court, but they lie in contract disputes, they lie in tort disputes. I don't know that there's any increase of lying in family law and domestic violence. I think it's not. I certainly think that based on what we're seeing, what happens when we make an allegation, if they believe making an allegation of abuse or domestic violence is going to help them, that they've been proven wrong by the numbers. So it's certainly not working for anybody because it's having the reverse effect. I don't think that we're going to see, you're always going to have a percentage of people in every field that will game the system in some way. I don't see this as giving license to folks to game the system. Courts are still going to be required to make the determinations. This is not going to be someone just makes an allegation of abuse, therefore they win, they get the kid, and all these other factors put aside. We're saying this needs to be factored in before the court moves on to the other factors is really all we're saying. We're reminding the court of the focus of where it should be first, and then to the other factors. And the courts have proven adept, rightly and wrongly, at ruling out abuse when the courts don't think it happened. I don't think judges' hands are going to be tied by this legislation. I hope that addresses your question, Delegate.
Thank you, sir.
Thank you, ma'am.
All right, are there further questions for this panel? Seeing none. Thank you all very much. There appears to be one person in opposition, and that is Vince McAvoy. Is Mr. McAvoy here? It's coming in. Mr. McAvoy? Mr. McAvoy? Mr. McAvoy has to connect to audio. He appears to be having difficulty. He appears to be having difficulty. I don't know that we're going to be able to do this. Okay. We will, if we can, we'll try and give him an attempt, opportunity. If we can figure it out before the end of our hearings today, we'll try and give him a chance to talk. But for now, that concludes the testimony for House Bill 748. We'll now go to two bills from Delegate Arakan. Delegate Arakan's bills 931 and 930. There are three people signed up to testify on 931, including Delegate Arakan for 3 minutes, and then Maria and Aiden Mosovitz for 2 minutes each. So why don't we start with that one, and we'll hear from those three people, and we'll go from there. All right.
Thank you, Mr. Chairman, Madam Vice Chair, and my friends of the Judiciary Committee. I'm here in support of HB 931. You guys did hear this bill last year and got to meet the victim and his mother last year, who were the impetus for this bill. This bill would require that if there's an instance of alleged abuse or neglect that occurs in a daycare setting, that the moment when a mandatory reporting is triggered in the already existing statute for mandatory reporters, that a letter, phone call, or a verbal notification must then also be sent home to the parents or guardians of the children that were present in the classroom and may have bared witness or may also be potential victims of the alleged abuse or neglect. Parents deserve to know what is happening to their children when they're in daycare. You will hear a terrifying story after this, which many of you have already heard, where alleged abuse occurred. Ultimately, it was found fact sustained, but it took weeks or months before the parents ever knew, even though the daycare knew and had reported it to the police. The parents were not alerted, and that is unacceptable because, as many of you know, ACEs, childhood adverse experiences, need to be addressed as quickly as possible to help people start healing. And letting children go for months without getting them the help that they need is unconscionable and can't be tolerated anymore in the state of Maryland. So I'm here to support this bill 931. I hope that you guys will all support it as well. It's a small change, but parents have a right to know what's happening to their children and know if their children might need mental health care. So thank you very much. And I will pass the ball on to our witnesses.
All right. Why don't we hear from Aiden first? Aiden Mosovitz, please. You need to unmute yourself. And we'll hear from you for 2 minutes.
Hi, we'll hear from you for 2 minutes.
Oh, but you'll have to turn down me in the background. If you've got us on in the background, you have to turn us off. All right? You ready now?
Can you?
We can hear you.
It's working. It's working, Aiden. You got it, buddy.
You got it.
There you go.
All right, go ahead, Aiden. 2 minutes.
Read it.
Hi, my name is Aiden. I am 10 years old. I wanted to testify on this matter to urge you to please support this bill so no other family or child has to go through what my family and I did.
All right, thank you very, very much. We'll hear from Mosovitz now. You have to unmute yourself, though.
Sorry.
Go ahead.
So 2 minutes to sum up one of the most horrific days that I've actually ever encountered. January 12th of 2017, I received a phone call letting me know that I had to come in and talk to them because they found proof of, my child being sexually touched and everything. And I really couldn't talk with her on the phone. So then I drove all the way to the center because as a mom, all I wanted to do was to get to my child. And when I finally got there, I went in the office and I started talking to the director, Kelly, at the time. And she had mentioned to me that during an investigation that was reported at the end of August, beginning of September, from a first allegation from another child, that they came across a video of my child being sexually touched inappropriately in December, somewhat in December. And of course, I questioned this because they're reporting it, first allegation, end of August, beginning of September. They found the video apparently sometime in December of 2017, but I'm not hearing about it until January of 2018. And I have spoken to some parents since then, and they still don't know what had happened at this facility. And many are shocked to find out that my child wasn't the only victim, that my child was, one of a handful of victims. And the only response I got was the reason for the delay was because they had to investigate, and the investigation of everything. And that is the only response that I got. I didn't get, I didn't get anything else. And the minute I found out is when we went and sought treatment for our son and found out from our son that it was a lot worse than what they thought it was at the daycare. And my son was not only inappropriately touched, but he was inappropriately fondled and sexually, things done that, no parent ever thought. I trusted them with my child. And to come to find out that the trust was misplaced. This bill, I don't want any family's life to be turned upside down. I think parents have the right to know when their kids are in danger or possible danger. I think that kids have the right to get treatment when possible allegations have been made, to find out, who else are the victims and things of that nature, because we're finding out little by little there are more kids. And none of these other parents knew about this prior to me actually saying, hey, this is what happened. And of course, I only speak about what happened to my child and how they treated me, because I don't know the other, what happened with the other children. But my son isn't the same. My son, lost trust in people. He doesn't trust a lot of teachers. And if he does, it's a blessing. He thinks that they're supposed to be his protectors, and a lot of them at Celebrity Daycare Center actually basically let him down. And this hurt us in many ways. Sorry if I sound emotional, but I'm still
fine.
dealing with a lot of it from what happened.
We thank you very much for testifying with us today, and we thank Aiden as well for speaking with us today as well. Let's take questions from the committee. Are there questions for the committee? I don't see any. There are no questions from the committee. All right. We'd like to thank you again, both of you, all three of you, for testifying here today, but that concludes the testimony for House Bill 931. Thank you again. Thank you for coming forward very, very much.
Thank you.
Thank you. All right, Delegate Arakan, we're now going to go to House Bill 930. House Bill 930 will be you for 3 minutes, then Michelle Smith, Julianne Bartholomew, Shanta Trivedi, and then we will go to one person in opposition. So Delegate Arakan now for 3 minutes, please.
Thank you, Mr. Chairman. For the record, Delegate Lauren Arkin here in support of 931. I'm sorry, this is 930. So this bill you also heard last year. This one deals with removing the risk of implicit bias in child removal cases. I hopefully you guys have a copy of the Nassau County study. In Nassau County, New York, they implemented this type of child removal meeting where it strips from the file all kinds of identifying information that someone might have implicit bias about. So think ethnicity and religion and all kinds of different things, and it's all listed out in the bill, but they removed a lot of these things and they decreased their child removals by 54%. And they had no adverse outcomes for children in the county. So, I mean, that number is so staggering to me. There is, in my mind, all I can think is that probably half of the children we're taking from their moms and dads right now probably don't need to be taken and maybe being removed for reasons of bias. So this issue, as I mentioned last year, came about because I had an Orthodox Jewish family, actually two, contact me from the same district. And they had felt that they had been specifically targeted because of their beliefs. And so that's how I started researching this topic. And that is how I came up with this bill. And I hope that this year we'll get an opportunity to move this bill through. There is, I'm not opposition, but a letter of information from DHS. They have a type of meeting that they prefer. But this is, I think, going to be the best practice across the country. And I think that we should be leaders on this issue, especially since we're working on these kind of equity issues across every department. I don't want to leave out a department that has so much power over families in our state. So I appreciate you all, and I hope that you'll love this bill as much as I do. And I look forward to hopefully answering any questions you might have. Thanks.
All right, let's go to Michelle Smith, please, for 2 minutes.
Thank you, Mr. Chair and Madam Vice Chair and sponsor, Arakan. I too do think this is an excellent bill. I am here, Michelle Smith, on behalf of the Family and Juvenile Law Section Council of the Maryland State Bar Association. The Section Council does urge a favorable report for House Bill 930. As the delegate said, it does seek to lessen the impact of racial and lots of other implicit biases based on the issues of such things as gender, socioeconomic status, cultural and religious beliefs. And it takes that out of the consideration of the decision makers in the child welfare system who are thinking about removing a child from that child's home. As we all know, such a step, removing a child from the home and from the parents, is a drastic and potentially destabilizing event in the lives of course, the child, but also the other family members. That decision should be made without the interplay of personal biases Even if people in that system do not realize they have biases, they may still have them. And I understand that there is no doubt that requiring the redacting of those personal identifiers in the investigation reports, in the meeting notes, will also require revisions to the system and perhaps even additional training. However, the end goal of a bias-free decision is worth that extra work, according to the section council. So we do urge a favorable report and have lots of high hopes for good results.
Right. Julianne Bartholomew, please, for 2 minutes.
Thank you, Mr. Chairman, Madam Vice Chair, and members of the committee. Thanks for listening to my testimony in support of House Bill 930. I worked for the Division of Child and Family Services, or DCFS, in the state of Utah as a social service caseworker before moving to Maryland in 2004. I remember my first few months on the job feeling overwhelmed that all of a sudden I was supposed to be the judge of what was normal. We had lots of trainings, but we also had a lot of leeway in judgment calls. Who your caseworker was could definitely affect your case. When I went to court, the Attorney General, who represented DCFS, and the guardian ad litem, who represented the best interests of the child, almost always presented a united front in front of the judge. Even the most diligent guardian ad litems appeared to rely heavily on the information provided to them by DCFS. My words and the words of my colleagues had a lot of power. Recognizing this has made me scared of social services ever since. Even though Utah is a predominantly white state, at least half of the cases that I worked were with minority populations, and most of the white families that I did work with were not members of the predominant religion in Utah. No one I know of wanted to break families apart. We wanted to protect children and strengthen families, but somehow the families that came into the system were disproportionately from minority backgrounds. I worked with one Black mother who lost her children due to a combination of parole violation and drug use. She was incarcerated as part of the process, and because she was incarcerated, the judge terminated any visitation rights she had with her children. It wasn't possible for her to do most of the things she needed to do in order to get her children back while still incarcerated. The day she got released from prison, she came to my office and asked if she could see her children. I told her she would have to take it up with the defense attorney and get the court order changed. That night, she overdosed on heroin and died. I don't know if she did drugs because she couldn't see her children or if she would have done them anyway. But I do know that separating families brings pain to everyone involved and that we should do everything that we can to make sure that those separations are absolutely necessary, that they are to protect children from abuse and not due to any personal biases that someone may implicitly or unconsciously possess. I urge you to please support House Bill 930 to protect all of our families. Again, thank you for listening to my testimony.
We could have Shanta Trivedi now for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, and committee members. My name is Shanta Trivedi. I'm a clinical teaching fellow at Georgetown University and previously taught at the University of Baltimore. Before teaching, I represented hundreds of low-income, primarily minority parents in the equivalent of SINA cases in New York. I research and write in the area of child protection, including a law review article entitled The Harm of Child Removal. I support the passage of House Bill 930. As I detailed in my written testimony, data demonstrates that there is bias throughout the child welfare system, both nationally and right here in Maryland. Minority children are more likely to be removed from their parents than white children, not because minority parents are more abusive or neglectful, but instead because human beings are imperfect. It is clear that as a society, we make assumptions and judgments about people of color. For example, hospitals are more likely to evaluate and refer minority parents for suspected abuse. And data proves that our legal systems judge minorities most harshly. Poor children are also most likely to end up in foster care, often because poverty is conflated with neglect. Children are removed because of unstable housing, because their parents cannot afford childcare, and due to so-called educational and medical neglect. In my experience, upper-class parents engage in many of the same behaviors as indigent parents, yet they rarely get a call from CPS. To be clear, I'm not suggesting that white or middle-class parents be treated more harshly, simply that all parents be treated fairly. The horrific images of children separated from their parents at the southern border are seared into our minds. But children are separated every day right here in our courts. And data shows that these children will suffer lifelong harm and have worse outcomes than their peers on every metric, from their health to their likelihood of criminal legal system involvement. I firmly believe that eliminating demographic information from consideration in removal meetings is a necessary and honest step towards equity for children. And I thank you for your time and urge you to issue a favorable report. I'm also happy to answer any questions.
Are there any questions for this panel? Are there any questions for this panel? Seeing none, thank you all very, very much. That concludes the favorable testimony for House Bill 930. We'll now go to an opponent, Stephanie Franklin. Stephanie Franklin? All right, let's try that again. Stephanie Franklin.
Yes, I'm sorry. Can you hear me? And can you-
Yes, that's just fine. We'll give you 2 minutes to address the committee.
Okay, great. Good afternoon, Chair, Vice Chair, and committee, and thank you for allowing me to testify before you today. I'm urging this committee to find an unfavorable report for this particular bill. While I agree wholeheartedly with the proponents of the bill regarding the disproportionate impact that it's having, particularly on Black families, and particularly those families who are descendants of captive and enslaved Africans in the US, we disagree on the mechanism within which that needs to be done. The information provided about the Nassau County report and the blind removals is an erasure of culture, erasure of identity, and erasure of history and lineage. We are at a critical point in this nation, and not only in this state as well, that we're going to have to deal with the root of what caused racial issues. And what I feel is that this is a short-sighted strategy to really impact and remove a weed that has been so damaging to Black communities in particular. And I'm saying that in particular because I am the president and CEO of the Franklin Law Group. We provide legal representation to abused and neglected children across the state of Maryland. We've done it for 14 years, and I personally have done it for over 22 years. And so having said that, when we look to erase culture and identity, it impacts a number of things: the type of supportive services that will be offered, the type of placement that will be offered. These things actually do undermine the essence of really supporting the best interests of children and the best interests of families. And so the Nassau report that's been cited, there's some controversy around that. I'm hearing from Delegate Arian that there was high success in that county, but there's some contrary information to that I know was submitted by the National Association of Social Workers that I'm assuming that you all have. And so what I think that the best mechanism, the best strategy is to assemble a racial disparities task force for Black children who are entangled in the child welfare system. And I specifically say Black children, and specifically those of us who are descendants of captive and enslaved Africans in the US, because our kids are about 31% of the child population under 18 in the state of Maryland, but yet make up 55% of the numbers of children in foster care. This particular racial disparities task force for Black children in the child welfare system or entangled with the child welfare system should really assemble those who are expertly placed to be able to come up with a strategy and a mechanism to actually address these blind removals. Or these removals, pardon me, because I know that the
Ms. Franklin,
for blind removals. Yes.
Ms. Franklin, I need you to wrap up your testimony, and then there will be questions.
Sure. The task force needs to be expertly stacked with practitioners and directly impacted people, meaning parents who were formerly engaged with the child welfare system as well as children.
All right. Thank you very much for that. We'll hear the question first from Delegate Arikan, please. Delegate Arikan.
Thank you, Mr. Chair. Thank you, Ms. Franklin, for being here. So you represent children in these cases, is that correct?
That is correct.
Okay, and so the bill is written, did you, maybe it was confusing, it does not impact FEM meetings. this would be a separate meeting held in advance. So a child, for example, who was Muslim or was Jewish or was Black would have the opportunity in the FIM meeting, if a removal was decided on, to then place that child in the culturally appropriate place that the family wanted them. So that the concerns about stripping away the culture, it would not impact that at all. This would just be a prior step to that. So after they've made the call, they can absolutely discuss all of the important things about being a member of the Black community or of the Orthodox Jewish community. Those things are important, and we don't want to strip the child of that identity at all. We just want to make sure that that's not playing into the removal decision.
Yeah, I understand. I wholeheartedly disagree. I think that we need to get at the root. We talk about implicit bias. There's also explicit bias that we don't like to talk about a lot. And so again, this is a short-sighted strategy. How long, we're in the 21st century. How long are we going to try to utilize short-sighted strategies to actually address systemic harms that have happened for centuries? And doing this is basically saying, we're erasing you. We're erasing you. And so to make sure that we do this right, because we don't want to actually challenge ourselves to evolve and grow as human beings, we're just going to remove all this information because we just can't do it. I push back on that. I believe that we as a people are better than that. And because I believe that we are better than that, we need to do deeper work to dig into the truth of history and how it's impacting present day. I wrote an article that I forwarded to you, and it's in a child welfare law journal called the National Association of Counsel for Children, and it's called In Search of Reparatory Justice, a Child Family Welfare Act for Black descendants of captive and enslaved Africans in the US. And I'm specifically speaking to Black decals people because we are the ones that are bearing the brunt of the separation of families and the violence that has occurred over centuries that's never been repaired. It's never been repaired. And people don't want to get at the root and speak to the cause of this because they don't want to be truthful about it and or they don't know about it. Because historically, we've been given completely inaccurate information. So what I'm saying is that the strategy that you are proposing, very short-sighted. It's short-sighted. How long are we just not going to look at people and then make these type of decisions?
Okay, I understand. Yeah. If we included
to really address this from a perspective of being very knowledgeable, not just, okay, I was removed because of this reason. There are racial justice advocates and activists across this country, including myself, who are well-versed in the child welfare realm, who can speak to this issue in ways that I think would be more expertly served and cogently able to represent what I think is appropriate for instituting a mechanism to get rid of the quote unquote implicit bias and explicit bias. This is a systemic issue that needs to be changed.
So if there was a commission added to the bill, would you support it? Just a yes or no is fine.
I'm not certain.
Okay, thank you.
That would be something I would have to look at what the bill looked like.
Delegate Conaway for a question.
Thank you, Mr. Chairman. Thank you, Pat, coming in. Ms. Franklin, if I may, thank you for your testimony. My question is, if you try to examine a child whose culture comes from generations of people who were raised in the projects and brought themselves out of the projects through their culture of self-determination, how can someone understand that child and that child's mental attitude towards bettering themselves when they have no clue about going through the projects themselves? Is that an example of what you're talking about?
Which is why I think there needs to be some task force. We need people who really understand this issue. And I'm not so certain because I'm familiar with this particular Nassau County study. I wholeheartedly disagree with the proposal. I do think it's short-sighted. We need people with more expert information that can speak to the heart of this issue so we can address it head on. This is the time.
Thank you so very much for your testimony.
Thank you, Delegate.
Are there further questions? Seeing none, we thank you very much. That concludes the testimony on House Bill 930. All right, we're going to go now to two final bills. It's only 3 o'clock. Two final bills from Delegate Dumais. House Bill 505 to start, and this is going to be including Delegate Dumais, Smith, Dorothy Lennig, Lori Ruth, and Eric Smith. He's coming in favorable with amendments, but we'll bring him into the first panel. Delegate Dumais will get 3 minutes, and whenever you are ready, go right ahead.
All right. Thank you very much, Mr. Chair. Good afternoon, members of the committee. This is a bill that you've heard before, so I'm not going to belabor it. As this is a bill that would provide, we would then have a custody statute. At the moment, there is nothing in our statutes that define how a court should make a decision regarding custody. There's lots of case law, and certainly when I do my closing arguments in custody cases, there are 2 cases in particular, and I've got all the factors listed. And as part of my closing, I always go through the factors to direct the court to here's at least my position on the case as to how the court should look at these factors and determine the best interest of the child. In 2013, the legislature established a commission called the Child Custody Decision-Making Commission. It was chaired by Judge Cindy Callahan, who's from Montgomery County. The commission had about 25 people on it. We had mental health professionals, actually Ms. Ruth and Ms. Lennig, who you'll hear from, both served on the commission. We had family law attorneys. We invited fathers' rights groups to participate, judges and clerks. We divided into subcommittees, and as a result, we had over 200 people involved in this commission, which issued a report, and this statute is one of the results. What the statute really, or the proposed bill does, is just lays out these are the things that we think the court should consider when they're making a custody determination. There are a total of 15 factors. But more importantly, what the statute does is we think it shifts the paradigm to be able to talk about custody in a way different than who has custody and who has visitation, which is a word I have never used in my practice. I will talk about parenting plans, I'll talk about access schedules, but I don't think any parent just visits with the child. So instead of talking about who has decision-making, we instead talk about decision-making authority and how do you share it. Instead of talking about visitation or access and physical custody, we talk about parenting time and how do you share parenting time. In addition to, I think the statute would be a wonderful thing to have, but we did more than just that. There was a committee that talked about court process, and it's a long process to get anything through the Judiciary's Rules Committee, but we actually did. And now, as part of the court process in any custody case, a parent, or both parties actually, both parents, have to complete what are called parenting plans and submit them to the court before a custody case. But those parenting plans mirror what this custody statute would do. I think it's important the number of self-represented litigants, particularly in family law cases, because unfortunately, actually handling these kinds of cases can be very expensive. But if there's a statute and people can be directed to where to go, they will have a better idea of what it is they should be presenting to the court. Attached to my testimony, just so you know, are 2 very minor clarifying amendments. And I had worked with the Judicial Conference so that they are actually supporting the bill this year. There have been times they haven't, but they support the bill this year with 2 minor amendments, just saying when the court's making issuing their decision, where we indicate in the statute they have to articulate on the record the basis for their decision. We've also added, they either say it on the record or they say it in a written opinion, either one. And then something else.
I'll have to ask you to start to wrap up. Sorry.
I will. Thank you. This last one was just, the only other amendment is to say that they don't have to give a weight to each factor, but clearly they've got the factors to guide them in articulating their opinion on the record or in an oral opinion. And with that, so I certainly hope for a favorable report, and thank you for listening.
All right, we'll go to Michelle Smith for 2 minutes now.
Thank you, Mr. Chair, Madam Vice Chair, and Sponsor Dumais for this excellent bill. Hello again, committee members. I'm still Michelle Smith here on behalf of the Family and Juvenile Law Section Council of the Maryland State Bar Association. It's been nice spending the afternoon with you. We urge a favorable report for House Bill 505. As Delegate Dumais just very artfully told you, the bill does seek to codify the efforts and comprehensive and well-considered recommendations of the Commission on Child Custody Decision-Making. There are the 15 factors that she referenced that a court should consider when deciding issues regarding custody and parenting time, as well as the revised nomenclature of decision-making authority and parenting time, which will mirror the parenting plan information that is already being provided to litigants at their first introduction to the court, the scheduling conference in their case. Such a codification continues the laudable goal of taking some of the mystery out of how to effectively navigate a child custody litigation for self-represented parents, and creates important clarity and uniformity for the litigants and the judiciary in a complex and emotionally charged process in which the stakes are extremely high. We urge a favorable report for House Bill 505.
All right, we'll hear now from Dorothy Lennick for 2 minutes, please.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. Once again, my name is Dorothy Lennick. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. As Delegate Dumais said, I served on this commission, and I just want to give you a little perspective on the commission itself. It had extreme, diverse thought. There were people from all different perspectives on the commission, which I think brought a wealth of information to us. And we traveled around the state holding public hearings. So we got a tremendous amount of information from people who've been through the family law justice system. And we worked really hard to come up with recommendations that addressed lots of people's concerns. So it didn't come from the feminist perspective. It didn't come from the father's rights perspective. It didn't come from the really expensive family law attorney perspective. We really tried to find what's in the best interest of the child, what's going to make the process work better, what's really going to be the most helpful for the most people. And this idea of changing custody and visitation to parent access time, I think really sums up the thinking. You don't visit with your children. You have time with your children. You have decision-making with your children. And I always say that my takeaway from that commission was nobody was 100% satisfied. I think we all walked away feeling like we came up with an incredible product, but we didn't get everything we want. And those of you who are lawyers, I think when you negotiate and you feel okay, but not like it was perfect, you probably came to a good decision. And I think that was the greatest thing that came out of this. I think we came to a really good product. I think this bill summarizes it. And I think this is something I really hope we finally can get a favorable report on this year. Thank you.
All right, thank you very much. We'll hear from Lori Ruth, please.
Good afternoon, once again, Mr. Chair, Madam Vice Chair, members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. We also urge a favorable report on this bill. I don't want to repeat what Delegate Dumais, Ms. Smith, and Ms. Lennick have said. I agree with every single word the three of them have said. I just want to add my own little piece, which is, by this point in my career, I've talked to literally thousands of people on the family law hotline since I went to the Women's Law Center in 2008. And, if we could do one thing for citizens in Maryland engaged in family law cases in our court system, passing this law to put those factors for custody into a statute that they could actually see and understand would be unbelievably helpful. And so, I know you heard Ms. Lennick in HB 748 earlier today say that over 80% of litigants in family law cases are unrepresented. Those are the people who call our hotline, and they have no idea what the court is doing. They often have no idea why the court decided what it did. And if there was just a way to try to educate the public, and my last point is the language update would also help change the society culture about what I often hear, the first words out of the caller's mouth is, I'm involved in a custody battle. And that is the language that is used in the citizenry about being involved in a custody case in a court system. They call it a fight or a battle. If we could change the language to legal decision-making and parenting time, it might start changing the thought process of people who require the assistance of the court to resolve these issues. And for those reasons, we strongly urge a favorable report on HB 505. And I really want to thank Delegate Dumais, who year after year fights the good fight on this bill. So thank you.
Right, Eric Smith, please, for 2 minutes.
Good evening, Chairman and Vice Chair. My name is Eric Smith. I represent Winning Strategies, Fatherhood, the Courts, and Custody today. I really have just 2 basic questions. Will this House bill ensure fairness by judges and magistrates, and will give each parent legal decision-making and parenting time, help to strike out the sole custody that is given to parents or to the mother rather than the father when they come in to apply for custody? Okay, no one has any criminal history, but disproportionately is sole custody is given to the mother. And sometimes only joint legal custody is given to the father. Okay, so we support this bill. However, if it could be an amendment that judges and magistrates start to look at this. Also, how can this House bill ensure that, again, the judges and magistrates will not strike any parent from their equal time? Okay, we help fathers. We tell them where to go at to use for their defense in getting joint custody. We just try to help them as best as possible because we aren't attorneys. And to go back off of something I heard Ms. Smith say earlier, when you spoke about best interest of the child, if it was, I don't think I would be here today because the Baltimore City courts are unfavorable to fathers. Thank you.
Are there questions for the panel? Delegate Thomas?
Thank you, Mr. Chair. I just want to say I've also kind of been involved in this for a number of years and have always kind of felt that to spell out what is in the best interest of the child, which is enumerating factors in statute, would be most helpful. And particularly over the years, more and more people are representing themselves. And I think it's an equity issue. It's an equity issue for those that cannot afford an attorney or that don't fall into the proper income level that they can apply for legal aid or for the volunteer lawyers. And I guess, and furthering it, what's the most precious thing, money or your children? Probably your children. Let's hope it's your children. And so people going in and trying to navigate how the custody and visitation of their most precious thing and doing it by themselves with all that pressure, it seems to be that this would really go a long way, at least to start leveling the playing field. And so what, Delegate Dumais, I mean, do you feel that this is kind of the way to go? I mean, because obviously we've seen 2 different chairmen with different philosophies, and I think now's the time. So what do you think?
I agree wholeheartedly. And I forgot to mention that actually Delegate McComas served on the commission with us as well. And in fact, I think the very first time a commission was suggested, it was her bill. So, I do think that this is time, and I think it would really go a long way, particularly with self-represented litigants. But to be honest, with the court as well. And I know you heard an earlier bill that there were lots of complaints about what judges do or don't do. The bench does a very good job, I think, training judges, and this would be an additional tool for the judges so that when they go through the family law training, this is what is talked about. And then there's a further discussion about what kinds of things fit into each factor and what should you be looking for. So I do think it goes a long way. I know they're already using the parenting plans for training, but You know, like I said, this is how I craft my closing arguments in custody cases, because I know what the cases are. I have the factors and I go through them. If it was in the statute, I could have that in front of me and just walk it through with the judge following along. So I do think it's the right way to go.
Another quick question, Mr. Chair, if you'll just beg your indulgence. Right now, we're seeing all over the country an erosion in trust and faith in our institutions. Certainly the judiciary is a very, very important institution. And any of the different folks that are proposing this bill, would you care to comment that this might help provide more confidence in the judiciary and their decision-making, particularly in custody cases, that they're going to be explaining why they came to the decision? I mean, in other words, is this doing something positive and moving the ball forward to put more trust in the judiciary?
I absolutely agree with you, Delegate McComas, and I too am sorry we didn't mention that you were also involved from the very beginning on that committee that commission that did so much work. But you know, I believe that requiring judges to articulate it, having the law be clear, having things that self-represented litigants can read so they don't think that judges or magistrates are just pulling it out of the air, can only improve their feeling that they were heard and that the judge, addressed the issues that were raised in front of them. And I absolutely agree with you that this bill would help provide faith that the system is working the way it's supposed to. And so I would encourage, that's why in HB 748, making the judge articulate why they ruled the way they did, to me, it's a very positive step.
I agree. And anecdotally, there's a judge in Montgomery County who is now retired, but the joke really in the criminal law circles was Judge Ann Harrington could sentence you to life, but you would leave the courtroom feeling like you had been heard and not be upset by it. That's what we want of the judiciary, is that you were heard, may not have liked the decision, but your story was told and you were treated fairly. And I think this would go a long way to moving that forward to judges. I mean, granted, I practice family law. I've been doing it for 32 years now. Some of the judges on the bench were prosecutors. They go through the family law training, but it takes a while to get the sense of what you're doing in a family law case. And I think this helps to strengthen that.
Delegate Conaway, please.
Thank you, Mr. Chairman. Thank you, Delegate DeMay, for bringing this bill. So you just kind of threw me off with that last comment about the judge could sentence you to life and you feel like, you were heard. That means that from where I come, the judge was able to psych your mind. So
That means you're treated fairly, I think.
Well, you were treated fairly. That means, again, the judge was able to psych your mind. So we're talking about parenting guidelines and what's the best interest of the child. We don't want to call this a custody battle, but we want to call it legal decision-making. But if one parent, let's say, has no problem with their child going to see Black exploitation movies, but the other parent says, well, I don't want my child to go to see those kind of movies. But the one that says it's okay to see the movies has the sole custody of the child. I mean, what do you call that when the child goes over to the house of the parent that would let them go to the movie? And that's exploitation, because they clearly know, the child clearly knows that my parent who has custody of me doesn't want me to go see Black exploitation movies. So you have a battle there. I mean, how do you get to parenting guidelines if you just have a split in your philosophy?
Well, in fairness, that could happen with an intact family. Even within a family where the parents are living in the same house, you can have disagreements about what your children should or shouldn't do, what games they should, video games they should play or not play. And the bottom line is the court's not necessarily going to be able to resolve those sorts of issues. What the court's job is to decide what's in the best interest of the child, and is there, unfortunately, sometimes from a decision-making perspective, on medical decisions, there are times where maybe the parties will have shared decision-making, but maybe the court says, Dad really is the one that's handled all the medical issues, and I'm going to give Dad the tie-breaking authority in medical issues. If it's an educational issue, maybe we're going to let mom have the final say on what. There are all sorts of things that can be done. In the case that you just described, that's almost one where I might suggest that they try mediation, so that they sit down maybe with, forget, not so much the court, but maybe they need to sit down with a therapist that can say, I know about child development, and here is, it's not a question of who's right and who's wrong, although in your example, I think in my personal opinion, there is certainly someone that's right. I don't think you ought to be watching racially explicit or racially, but having the parents sit in a room together and talk it through is really, the courts are not the best place. That's why we all talk about not liking battles or, custody fights. It all should be child focused. And how do we then get the parents to focus on the child?
That's fine. And I appreciate you entertaining my idea. Just let me say this. While the Black exploitation movies were bad, they also taught a level of survival skills. And
well, there you go.
As Clint Eastwood would say, sometimes a man has to know the point that he will not go beyond. Thank you.
All the more reason, if the two parents talk about it, maybe they'll understand the other's perspective.
Are there further questions for this panel? Seeing none. Thank you all very much. That concludes the testimony for House Bill 505. We have one remaining bill that I have to find over here somewhere. House Bill 893 has several witnesses. We're going to go ahead. Again, it's 3 minutes for Delegate Dumais, 2 minutes for everybody else. There are quite a few everybody else's here. So underway.
Okay.
Delegate Dumais, Harvey Schweitzer, Stephen Lutz, Andrea Widener, Chadwell English, and James McAllister. Delegate Dumais for 3 minutes.
Thank you. Let me see. I'm just getting something from the last about 30 minutes away. Anyway, okay. Thank you very much for hearing us today. This is, I think, the second year that I have had this bill. We've changed it a bit this year. This bill really is just to provide foster parents the right to intervene. They would have to actually request it. And then, and this is if it's a child abuse case or pre-adoption or termination of parental rights. These are individuals that have, and again, to be able to intervene, you have to have had the child with you for 12 months. So it's not a matter of you had the child for a month and you know everything. Child would have had to have been with you for 12 months. You're probably a good person that the court should, in fact, be listening to. And the reason there are so many witnesses, and I will suggest to the witnesses now that to keep their testimony, A, short because it's 2 minutes, but B, if you don't repeat what other people have said. But the reason there are so many witnesses is many of these individuals have been through this and want to tell you their stories. The bill is based on or very similar to what happens in DC, and it works. And Mr. Schweitzer, who practices in DC, is going to tell you why and how it works. And the last thing that I wanted to address, and actually two things. The judiciary doesn't like the fact that we suggest they give the notice. To be honest, I will submit an amendment to take care of that objection from the Judicial Conference and indicate it's the department that should provide the notice. The department is going to testify in opposition, but I think part of it is from the fiscal note, they think they need 2 people and $200,000 to allow additional people to participate in a hearing that's already happening. I think I want one of those jobs, to be honest. But aside from that, I think this really is just an access to justice issue, and important for the court to hear from individuals where the children have been with them for 12 months. It's a process question, not creating a new process. We're just suggesting additional individuals that have knowledge of the child be involved. And that's what the bill does. And like I said, I think the fiscal note is a little grandiose. Happy to take care of the notice issue that the court has. And you'll hear from Mr. Schweitzer, who's going to be able to talk about how it works in DC, and then you'll hear from a lot of foster parents about why they think it's important that they be involved. So, but again, I caution all of the witnesses that keep in mind, the committee's been here for a long time, and be short, sweet, and to the point. With that, Mr. Chair, I will turn it over. I think if Mr. Schweitzer's here, he might be the best to call next.
I am here.
Let's go to Harvey Schweitzer for 2 minutes, please.
Thank you very much, and thank you very much for the kind introduction. I've been involved in child welfare law since 1979, and since then have been practicing in Maryland and the District of Columbia. And it is true, this is an access to justice issue. It's an option for foster parents to intervene if the facts of the case call for that. The arguments being made against this bill are the same ones I heard 30 or so years ago when children were appointed attorneys and were allowed to intervene in child abuse and neglect cases. The sky is going to fall. Biological parents' rights are going to be undermined. It's going to promote friction and animosity between the biological parents and the children. None of that is going to happen. If animosity or adversarialness exists, it existed before and independent of allowing the foster parents to intervene. Foster parents usually don't need to be and don't want to be a party to a foster care case. This is an option for them to use if, under certain circumstances, the case calls for them to intervene. They aren't going to undermine the constitutional rights of the parents. The parents have skilled, experienced attorneys. They aren't going to undermine the work of the social worker. They're represented by the county attorney. What's the fear here by allowing foster parents to intervene? The judge is watching over everybody. This is not a cataclysmic change in foster care proceedings. The laws remain the same. The Constitution remains the same. You're giving foster parents an opportunity when it is needed for them to be able to participate as a party. No more and no less, but it's a very important improvement in the foster care system. There are times when foster parents really do need to intervene and need to be heard. This has been going on in the district for years.
Mr. Schweitzer, I need you to begin to wrap up, please.
Thank you very much. This has been going on in the district for years and in other states. And guess what? It hasn't eroded the foster care system, the rights of anybody, the powers of social workers. It gives the judges an additional voice, and it gives the foster parents advocacy opportunity in the courtroom.
All right. Let's go to James McAllister first, please. James McAllister for 2 minutes.
Yes. Good afternoon, Mr. Chairman, members of the committee. My name is Jim McAllister. I am the immediate past president of the Maryland Resource Parent Association, also an adoptive foster parent. My kids were in foster care for 4.5 years. It's a system that is tragically broken. And this is a different bill than the one we brought last year. Last year would have allowed foster parents to intervene at any time. We've compromised because the judiciary and some other stakeholders were concerned that having a foster parent jump in early would somehow disrupt the process. Let me explain to you how this works, because even though I'm a trial lawyer, I didn't know how it worked until I became a foster parent. When a child comes into care, a SENA case is open, that's child in need of assistance, and a judge is appointed. And the judge puts the stakeholders together and they come up with a plan for reunification. And there are specific rules, and Arnold E.B. is a man who's very well versed in those standards, but the standards are heavily weighted to reunifying the kids with their birth parents. And a plan is developed. And then if the child has been in care after a certain point, after a year, they start saying, well, maybe reunification is not going to work. And they start talking about changing the plan. But who's involved in changing the plan? The child has an attorney there. The birth parents have lawyers there. DSS is there. And a court-appointed special advocate, a nonprofit volunteer, is allowed to be there. But the foster parents are not. The foster parents walk into the courtroom, are allowed to make a statement, and then leave. And then things are said about what's going on in their house that they don't get to hear. Things are said potentially to the judge that are incorrect, or the foster parents may just have good ideas. Why do foster parents want to intervene in some of these cases? And keep in mind, it's opt-in. we have these children for 365 days a year. By the way, that's 8,760 hours. The DSS worker, if you're lucky, comes out and sees your kid for 30 minutes once a month. And then the child's lawyer comes out before these status conferences and spends about 15 or 20 minutes about 2 or 3 times a year. And the birth parents spend time at visitation. But we know what's going on. And yet we are walled out of the process. And the job of a foster parent, and you know, foster parents, we do it because we love these kids. We're parents, not caretakers or babysitters. Our job is to unscramble an egg that we didn't scramble. We're up with them when they're having nightmares. We take them to school. We see how they interact. We go to the conferences with their teachers. We know what works and we know what doesn't work. And
Mr.
yet
McAllister,
yes,
if you'd wrap up, please.
Sure. So we encourage the right to intervene because we think better informed judges lead to better informed decisions in what's in the child's interest. We're not looking to take birth parents' rights away. Adding players to the field does not change the rules of the game. And so, and also, we believe that this will lead to children not languishing in care year after year after year. It is incredibly damaging to children to be in care year after year after year. And Maryland ranks among the 4th worst states for kids who languish in care. It's not because we have some sort of monopoly on bad kids. It's because we have a bad system that doesn't incentivize or have anybody in the room that's really looking at permanency.
Mr. McAllister.
When it's in the child's best interest. We urge favorable.
Thank you very much.
Sure.
Stephen Lutz for 2 minutes.
Thank you, Mr. Chairman and Madam Vice Chair, members of the committee. My name is Stephen Lutz. I am a resident of Montgomery County. I am a foster parent. I have been so for over 2 years, active all that time. I've only had long-term placements, that is placements about 18 months or longer. So this bill is directly applicable to all of our foster experiences. I'm testifying in support of this bill. Excuse me?
Keep going.
Okay. So I'd like to focus a little bit on the accountability of caseworkers and how an involvement or their involvement can lead the system to provide a disservice to the children, specifically with an example from my own life and our own home. We had with us a sibling group for about 18 months, and from the outset, we were not provided adequate health history. We had vaccination record for one member of this group, but not another. And because it didn't exist, we'd had no discussion of the specific traumas that they'd endured. So we worked tirelessly as foster parents to get the appointments with the appropriate therapists, counselors, the medical professionals to obtain appropriate diagnoses. We had to work with the public school system and the children's school to get an IEP in place. We had to inform that school of our rights or lack of rights to participate in that IEP process. And the department was not involved until the very final meeting, when school was still not sure that we were not legally allowed to provide, to sign off on the plan, but that it had to be either a bio parent or a caseworker or some other department staff. And this was a massive achievement for us. We were very proud to finally get to that point. And after those 18 months, the children in our care were actually identified as needing treatment or therapeutic care, something we're not licensed to provide. And the department identified another home, another placement for them with treatment care, but yet no change of placement came. A couple weeks later, the department identified another placement with a brand new foster family, also not a treatment care facility or treatment care home. And then we get a call from the originally identified treatment care provider. When are the children coming? Why are you asking me this? Why are you asking at all? What the heck is going on with this case? How is it possible that the court can be hearing the truth and not taking action? This is just one incident that led me to believe the court was not getting the full truth and nothing but the truth in that particular case. So in all this time, the department was required to see our children in the home every 3 months. Yet in the 15 months prior to the COVID pandemic shutdown starting, our caseworker stepped foot in our home once.
Mr. Lutz, I'm going to have to ask you to begin to wrap up.
Okay, stepped foot in our home once, stood on our porch once, and sat in our car in our driveway a couple times. So there was one final Zoom to inform us of the change of plans. We really need this plan to pass, bill to pass. We need the opportunity to ensure the court is getting all the information. And more importantly, we need the opportunity to refute it when the court gets incorrect information. Please support and decide in favor of this bill.
Thank you very much. Andrea Widener.
Hi, thank you so much. My name's Andrea Widener. I was a foster parent in Montgomery County for 9 years. I'm going to skip my personal story because I think you'll hear a lot of those, but I will talk about the rights for foster parents to become part of the case nationwide. We've done research that shows that over 20 states allow this right. This isn't something that's abnormal at all. The most common is states like Colorado, New York, and District of Columbia that allow foster parents to be part of the case after kids have been in their care for a certain number of years. That's become a normal part of the court process in the states where this is allowed, and it hasn't bogged down the system. Allowing foster parents to be part of court hearings will not change the system or give foster parents more rights than birth parents. That's just not the case. It will allow judges to have a more complete picture of the children in their care, from the people who are taking care of the kids 24 hours a day. We also think this will speed up the court process by having someone there who's going to push for children to have a permanent home as quickly as possible. Maryland, as Jim mentioned, ranks 4th from the bottom in the nation in the speed that we find permanent homes for children. We're right between North and South Dakota. We should be doing much better. The permanent placement, we believe that it should be with birth parents first or with relatives. And if those aren't available, then placement with a foster parent, but that should be a last resort. I want to briefly mention confidentiality that's sometimes mentioned as a reason why foster parents should not be part of this process. When we become foster parents, we sign a strict confidentiality agreement, so we cannot share information about the children in our care or information we learn about birth parents. We could be prosecuted for that, just like anyone else in the case. So that risk is not something that we should be worrying about. So we hope that you will vote favorably on this bill. Thank you.
Thank you, Ms. Widener. All right, Stephen Chadwell English, please, for 2 minutes.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. Thank you for your attention this afternoon. My name is Stephen Chadwell English. My husband and I have been licensed foster parents in Montgomery County since 2018. We have been caring for a sibling group for the last 2.5 years. During the last court date in October of 2020, after being allowed to make a brief statement, one parent's lawyer requested we be dismissed from the proceedings. We were then asked to leave with no recourse. For foster parents, hearings offer rare and critical pieces of information that empower us to best parent children in our care. Reports of abuse, sexual or physical, or other details of potential trauma may connect puzzle pieces in our foster children's behavior that we otherwise would not be able to support or help. We need to see the whole child. We want the court to see the whole child. Foster parents open their homes and hearts to children with no certainty or predictability about our path and ahead. As such, having a seat at the metaphoric table is necessary to best empower foster parents to provide the most effective care to their foster children. Thank you. I urge a favorable vote.
All right, are there questions for the panel? There are several. Delegate McComas to begin, then Delegates Griffith and Cox.
Chair, this is for Mr. English. Would you be okay if you're from what of your testimony, you're not informed if there has been any trauma as far as psychological or sexual regarding the children? Is that fair to say?
It's inconsistent at best.
Okay, so if the child had a physical problem like diabetes and epilepsy, would they let you know?
Again, it would be inconsistent at best. For instance, medical histories may be piecemeal when we first get them. Now, if there's any immediate medical issues, of course, they are reviewed by a doctor upon first being placed into care. So those would likely be caught. But again, inconsistent.
Okay, and same way with school. If they had attention deficit disorder, you may or may not know that.
Yes, exactly.
Okay. Then this is just a question, I think, for the sponsor. Do you think that, well, okay, if this bill doesn't pass, Are the foster parents kind of invited into the proceeding at all? Does anybody subpoena them so that they're allowed to testify as what's going on with the kid now? So that, because I'm wondering if the word intervention is what's freaking everybody out, because it's like, okay, so they're a party to the case and they're not supposed to be, and we're afraid they're going to take the kids and all that. You know, there's maybe some baggage with that word intervention as opposed to witness. I can't hear you, Kathleen. We can't hear you. Kathleen?
Sorry about that.
Okay, all right.
And actually, Jim McAllister may also be able to answer this if he's still here, because he had to go to finance since he's been through it. But yes,
I'm still here.
Can be invited in, but they're not given a big role. But Jim, I'm going to let you do that.
Well, Delegate, it's the difference between being a witness and being a party. Is a witness comes in, testifies, leaves the courtroom, has no idea what's said after they leave, has no idea what's been said before they get there, has no idea what's being said about what's going on in their home. So for instance, DSS, who spends 30 minutes, if you're lucky, with your kid once a month, is informing the judge about how the placement is going. How are the kids doing in school? How are they interacting with other kids? How are they doing in terms of their therapist that they're seeing? How are they doing with their doctor and dental appointments? We do all that, but we don't know what's being said about us. And there's a concern by several foster parents that things that may be said about us are inaccurate. Or construing the facts most favorably to the DSS workers who are overworked. It also lends itself to a more complete record for the judge to hear, because when somebody says, oh, well, he's not having a problem with bedwetting, and in fact, that kid is having a problem with that, you get to say, well, maybe that didn't come up in the half-hour session that you had with the kid last month, but I see that every night. So it leads to, if the judge is going to do what's in the best interest of the child and balance the blood rights of the relatives of the birth parents, which the judge is required by law to do now, those rules don't change. It merely gives the judge, a better informed source of information and a check on somebody who might mistakenly or not mistakenly say something to the judge that we know to be inaccurate. Does that answer your question, Delegate?
Yes, thank you much.
Okay.
Delegate Griffith.
Thank you, Mr. Chair, and thank you, Delegate, for bringing this forward. As a former foster child, this is my favorite bill in the whole House delegates last year.
Right.
Once again today. So, and as a foster kid, having dozens of kids rotate out of the foster homes I was in, seeing how many circumstances that a little input from the foster parents could have made for better outcomes for some of the kids that were tragically put back in really bad situations that I got experienced. But I want to get to my questions. So a couple of questions. You may have hit on some of this, but I want to clarify. A typical foster kid, how many social workers or caseworkers do they get over the course of their time in the system?
I don't have an answer to that. Perhaps Mr. Schweitzer, who it's certainly DC, but he may, since he practices in the area of child welfare, may be able to answer that better.
Unfortunately, I don't have an answer, because my answer would be anecdotal. I do have to say that jurisdictions, including the state of Maryland, have improved the length of time that social workers stay with the case, but there's no guarantee that they will. Social workers leave their job, they're transferred. The changeover has been reduced dramatically over the years, but still there are some cases in which the continuity that needs to be there just is not there. And if I could, I would just like to make one comment. One of perhaps the single biggest change that this bill will make is foster parents can file a motion. That makes a big change in the legal proceedings. Providing information, yes. Being present, yes. Being able to provide and receive information, yes. Extremely important. But there are times when intervention is called for, that the reason why it's called for is a motion needs to be filed to get something done, allow something to happen, something should not happen and not be done, that nobody else is paying attention to, and the judge is not going to be aware of this unless and until the motion is filed. But look what happens. The judge will assess it and rule upon it, whatever in the best interest of the child in accordance with the law. But that is I have to say it, a power that foster parents do not have now, but which they should have.
Could I just answer real quick? For my most recent foster son, had 4 social workers and he was in care for 21 months. So I think there's still a lot of turnover, even if it has improved. For foster parents, we don't really see that. And for my foster son, a lot of information that one social worker have did not get transferred to the next social worker. For example, drug exposures. We were trying to figure out some medical problems, and I had information, but it wasn't written in the record. So the next worker didn't get that information and didn't believe me about that until they got some medical documents that proved I was correct, So,
Sure.
So anyway, I would say that it's still a huge problem. Foster parents are often the longest people to.
Sure. And Mr. Chair, if you could indulge me for one more question. Does anybody on the panel know what the typical caseload is for a social worker or a caseworker?
I don't.
If you would be willing to get that information.
Sure, yes, we can get the information to you.
I have some sense of it. It's substantial. But I think it'd be good for the committee to see. I really appreciate that.
Yes, I'll find that out.
Right, and if I could add, at the same time, there are guidelines that are issued by some organizations as to what's the ideal caseload for a foster care, for a worker in the foster care system.
Thanks.
Delegate Dan Cox.
Thank you, Mr. Chair, and good to see you, Delegate Dumais.
Thank you.
Looking forward to working with you in subcommittee on these great issues. And having represented foster families and children in that context, I sympathize with you, Mr. McAllister. Again, though, like I mentioned last year, I have some cautions, I think, in terms of parental rights. So I'm trying to find a middle ground here to maybe flesh out. And I thought my first question would be, Mr. Schweitzer, isn't it possible to do an in re motion, or excuse me, to open a case as the temporary guardian or custodian of a child? Couldn't you do an in re motion, in re petition, and then move to consolidate, and that would then prevent a question of parental rights divestment? And then in the context of that, I agree. All of these issues in terms of information that Mr. McAllister, you mentioned, these are things that really should be done. Isn't that something we could do in a statute without granting foster parents the same level of custody and control under the Troxel case, care, custody, and control that maybe that a parent has the sacred right to?
Well, Delegate Cox, you're a trial lawyer and you know how the courtrooms work. The judge applies the legal standards. The legal standards that govern reunification with birth parents are a matter of federal law and state law. So no matter how much time the foster parents have put in, by law, blood trumps sweat. So by being in the room and asking for something, we don't change the standard. Being a player on the field doesn't change the rules. So all we're there to do is to say, after a year, okay, and that's the compromise that we've offered this year, that let's bring in the foster parents, because reunification hasn't worked out, obviously. The kid's been in care for a year, and let's just see, is there something else? Is there something the foster parent might add that might help solve the reunification problem? Or perhaps, lead the people involved to think maybe reunification isn't an issue, but I don't think, and I apologize, by the way, for having a bird land on me while I'm in the middle of a hearing. At least I'm not talking through a cat face. But
We've
one of the
had
things
cats, we've had dogs, we've had babies climbing over,
well,
that's fine.
one of the things when you adopt foster kids, you get as pets. So I have, so I apologize for that distraction. But Delegate Cox, did I answer your question?
So just follow up though. So then the foster parent who is usually 100% or 110% invested in this child, and we know and we love them, but there is a financial incentive, and that person that receives that stipend per month would then be able to file a motion to TPR the parent's rights. Is that?
Well, the stipend, by the way, is $750 a month, which if you divide it, works out to $1 an hour for 24/7.
It's not much.
And so if there are foster parents out there that are getting rich on $750, if those of you who have kids, if you think $750 is getting you rich, God, please put me in touch with your broker. I don't think it's a financially motivated transaction. I think we care about these kids. We're parents. We're not caretakers or people that are babysitting the kids. We care, and we see things happen. You walk into a foster parent's house after 14 months, DSS comes in and says, the judge is moving your kid. Okay. And that's the way it works. And it happens all the time. Would you foster ever again if that happened to you?
No, in fact, for 7 years, I fought that because the rule, as you might know, is that there's not even a Fourth Amendment application. And I fought that for 7 years. So I totally agree. But I just don't know if there's a middle ground on that. But thanks so much.
I'd like to address the questions that you put to me. Number one, to file an in re or a miscellaneous action and move to consolidate is an awful long way around the mountain. Why just not allow them to be a party to the case? Number two, in Maryland, whenever I've tried that, it didn't work. In other words, I filed a separate case. I moved to consolidate. It's opposed. The judge has total discretion to grant it or not to grant it, and it just does not work. It's more straightforward to allow the intervention. Number two, allowing foster parents to be parties does nothing to change the Troxel case or any other Supreme Court case. In terms of the dollars and cents, if foster parents want to intervene and are allowed to intervene, they have to pay the freight for their own attorney. No court-appointed attorneys, no PDS, no free attorneys. If they feel that strongly about having to intervene, they put their money where their mouth is in these kinds of a situation. Lastly, about the fear of a foster parent being able to file a motion to terminate parental rights. Number one, I'm not so sure that they have standing to do that in the state of here, but if they do, so what? They file it. The judge will hear it. The judge will decide the motion. It'll be dismissed. It'll be granted. What's the fear here? The District of Columbia for a long time was the only jurisdiction that allowed children to file for termination of parental rights, and is one of the only jurisdictions that allows foster parents to file petitions to adopt without the permission of the agency. Guess what? The system is still there. Everybody's legal rights are intact, but the judge and the system are forced to confront certain issues and certain situations that they wouldn't have to confront otherwise, which leads to more comprehensive and more refined answers and solutions for the children. The system should not fear foster parents as a party to the case. I think that there are a lot of people right now, legal services, public defender, county attorneys, social workers, who are very comfortable with the status quo. Fine. Their attitude is, if it ain't broke, don't fix it. It's broke. Let's start to fix it.
Thank you.
Delegate Williams, please.
Thank you, Mr. Chair. A couple of questions. One, I just want to thank Delegate Dumaine for bringing forth this bill. One, I read the Office of the Public Defender mentioned that they would like to see kind of an exception or at least enumerated so it's explicitly clear that this would not apply in CINA cases. I don't know if you have a comment with regards to that statement from the Office of the Public Defender. And then secondly, I so noticed that the judiciary was making a comment about how the 10-day notice probably would be better served coming from, I guess, the Department of Human Services. So I just wanted to just wonder if you had a comment on both of those things that were brought up in some of the written testimony provided.
I haven't seen the Office of Public Defender's written testimony, but I will take a look at it and certainly get back to you unless Mr. McAllister and Mr. Schweitzer respond. As to the judiciary's notice piece, I'm going to have an amendment prepared and we'll take care of that issue.
Okay, all right, that sounds great.
That one's easy.
Okay, Mr. Schweitzer, I don't know if you have anything to
My only
add.
comment would be is that the written testimony, I believe it was from the Public Defender Service, addressed a different proposed bill than the one we're talking about.
I mean, I can't imagine why they would not want it to occur in Senate. So I'll have to look at sort of what they're.
Yeah.
Yeah, we think there was a cross filing, maybe they switched.
Yeah, I mean,
'cause it
that's
seems to be
exactly what
about
we're
five-
talking
it seems
about
to be
here.
Oh,
about the
I
previous
see. You know
bill.
what? This is regarding 505 and we're on
Yeah.
93.
We think
Okay.
we think it was
accidentally.
probably they've just crossed.
Got it. Okay, because I was wondering that too, and I was like, okay, so all right, that was really kind of all of my questions, but I appreciate the bill. I appreciate the conversation. I have friends who have been foster parents and have gone through this process and feel just as strongly as the biological parents or any of the other intervening parties in these types of situations about what is in the best interest for the children. And so I agree with the comment. If they feel that strongly, they will hire an attorney to fight for what they truly do believe is the best interest of their children, because they're just as emotionally and financially invested, I think, as any other party. So those are my comments. Sorry about that, Mr. Chair.
That's all right. Thank you.
Delegate Erican, please.
Thank you, Mr. Chair. For the maker of the bill, I was a little concerned when I heard that there would be no court-appointed attorneys, only because are you not worried that then only rich foster parents would be more likely to be able to keep their kids? Because we know if you have an attorney, you're way more likely to get,
So here's my thinking. I in general think that there should be counsel in all custody cases, whether it's in a divorce case or anything else. I served on a task force, legislative task force, probably 7 or 8 years ago. Bobby Neal was the chair, so we could look at access to justice and assistance of counsel and what other states are doing to fund it. The bottom line is there's not the funding available. If I had a pot of gold and could do it, I would. That task force basically indicated that the types of cases that really should have state funded or private, some sort of attorney appointed and paid for, or anything to do with custody, which would certainly include foster, housing, which we're certainly seeing, and disability benefits. Those were sort of and domestic violence. Those were sort of the top ones. We just don't have the funds to do it. Now, if a foster parent qualifies from an income perspective for a legal aid attorney, that's a civil procedure, and it's certainly something that they could explore. But, I would love to have there be court-appointed counsel, but there's just not the funding available for it. It doesn't mean that these foster parents can't proceed without counsel. There are usually court forms. The court has been really good, but the more there are self-represented litigants, the more the court makes forms available so that there could be a form motion to intervene. I appreciate your question, and there's nothing I'd like better, but I just don't know where we find the funding.
my other question, just real quick, is also to the maker of the bill. Hearing all the details that goes on in the court case is potentially going to open up the parents to more bias against the biological parents. And I have many friends who I love and think are fabulous foster care parents, but I have never heard one of them, not one, say they thought that the children should go back home. And they are already, in my opinion, very biased against parents because of the things that the children may have said, true or untrue, about the parents. So is there a concern that you have that a foster parent hearing all of the details could lead to more bias in the foster parent's mind, which they could then put onto the child who already has a tenuous relationship, who's working to try and, reunify? Are you worried at all that having access to all that information could hurt reunification, prospects?
I mean, I'll answer, but I also think you're going to hear from other foster parents today that will do that. And it's a double-edged sword. On one hand, it's important for the foster parents to know what the child has been through and what the child has faced. I understand your perspective about, is that going to be too biased? But again, it's not the foster parent that's making the decision as to whether or not the child is going to be reunited with a biological parent. It's the court, with the assistance of the department, who is the social workers that have the handle, allegedly, on biological, or the attorney for the biological parent. So there are enough people, I think, in the room. Sure, I think sometimes that there may be some bias, but again, it's not the foster parent that's going to make the call. And I think that's the distinction.
Yeah, my worry was less about the end judgment and more about the potential to harm the already existing relationship between the child and their biological parent. Because, if you have a divorce situation, one parent says negative things to the child might start not liking their dad. You know what I mean?
I see it.
That third, just more information coming in, more things that will make the foster parents say, oh, these people are nowhere near as good of a parent as me, which they're usually not, right? Mm-hmm. But the best parent is always what the child needs. Sometimes it's their parent, the one that
I know. Well,
so
I agree, and that's why it's the judge that makes the call.
All right, thank you very much.
I don't know any foster parent who talks badly about birth parents in front of their foster children. It's just not something we would ever do. We believe that birth parents and foster parent and kids should have an amazing relationship, whether they can go live with that parent or not. And especially when they are in our home, we would never say a bad thing about a birth parent.
I know.
We already know a lot. We just don't know everything. So,
yeah,
and I think oftentimes the things we don't know really hurt the way we are able to help our kids. Like, we do not get information about drug exposures, about violence, about that they've experienced or witnessed. So there are a lot of things that I think the disadvantages outweigh the advantages.
So. I appreciate that perspective a lot. Thank you, guys.
Yeah. And the other thing is, intervention and what foster parents say to their children, the foster children, are not connected. I agree with Ms. Widener. It's very, very rare to have a foster parent who undermines the biological parent-child relationship, but intervention isn't going to change that. And the other point that I would make is, sometimes, well, how should I put this? I'll just stop right there.
Thank you. Okay. Thank you, Mr. Chair.
Are there further questions for the panel? Seeing none, we thank you all very much. We'll go on to our next panel now.
All right. Thank you, Mr. Chair.
Thank you. Morgan Gable, Rebecca Wazik, William Blevins, Maheen Taki, Joy Booth, and Michelle Wolf. Let's start with Morgan Gable, please.
Hello, everyone. Hopefully you can all hear me. My name is Morgan Gable. My wife and I reside in the Upper Fells Point neighborhood of Baltimore City, which happens to be Chairman Clippinger's district. I also currently serve as the vice president of the Baltimore City Resource Parents Association, which is a nonprofit group of foster parents in the city that we are trying to rebuild. We've been lucky enough to be foster parents for the last 19 months to what we believe is the most adorable little 6-year-old boy in the world, although we may be a tad biased. Our foster son has had 15 court hearings over the past 19 months. At one point, he had one hearing every single month. Not one time were we informed in writing about the hearing from DSS in advance of the case. The few times we were informed via email by someone at DSS. Very rarely would we hear directly from DSS about what would happen directly after or ever during the case. All day we would wonder and sit around thinking about whether or not our foster son would be returning to his biological mother's home that very day. Most times after waiting all day, we finally come to find out that either the hearing was postponed or it was canceled entirely and nothing happened. We've been fortunate enough to forge a strong relationship with our foster son's attorney, who keeps us posted on hearings and events that occur during these hearings. His attorney had asked me to appear as a witness three separate times during 3 separate hearings. Each time I sat in the virtual waiting room, not once to be called by the judge after sitting in the waiting room for 2 hours each time. Without our child's attorney, we would have no idea what is going on with our foster son because the communication from DSS is so horrible. We have been forced to endure unsupervised weekend visits during a pandemic. We constantly worry that our child will be exposed to the coronavirus and will then bring the virus back to us and to our home. As everyone knows, foster parenting is hard. We've had to file a CPS report after suspected physical abuse from a weekend visit. We've had to talk to the police on more than one occasion as a part of their investigation. We've accompanied him to the pediatric ER for mandatory abuse examinations. We set up virtual therapy sessions and ensure that he attends them weekly for his mental and emotional health. We have recently, as of yesterday, taken him to the Baltimore Center on Child Abuse for a forensic interview after sexual abuse allegations have been made. We've taken him to get a paternity test. These are just a few examples of the many things that our foster son has had to endure, with us there by his side, supporting him every step of the way.
Ms. Gable, I need you to begin to wrap up, please.
Will do. We've done all these things without hesitation, in addition to normal parenting, assisting with virtual school for almost a year, going to soccer, doctor's appointments, and loving him unconditionally. We do all of these things, yet we are not allowed to listen to what is said about him or what is said about what is going to happen in his future during any court proceedings. Thank you for your time. I urge you to find this bill favorably. It supports foster parents and the foster children for whom we so deeply care about.
Thank you very much. Rebecca Wysick or Wasick.
Oh, that's Wasik. Thank you so much for allowing me to testify today. While this bill is written as an expansion of foster parents' rights, I ask that you also consider it as an important enhancement to foster children's rights. These children have been through countless traumas, and they deserve to have the people who know them best present in the courtroom to advocate for their best interests. I became a licensed foster parent in Montgomery County 17 months ago. Within 2 days, I welcomed an emergency placement of 6 and 9-year-old sisters. Immediately after that placement, I became the foster parent to a girl of 1.5 years and her 3.5-year-old brother. They have been with me ever since. Unlike what Delegate Griffith was saying, they have had some relative advantages. They've had a consistent social worker, consistent attorney, consistent CASA. And yet I still don't think that's enough to ensure that they get the best outcome here. In the past 16 months, as you know, attorneys don't visit very often. So the attorney has visited twice with the children in 16 months. And again, the social worker is only required to visit on a monthly basis. But these are the people who are representing the children's best interests in court. So I think to balance things a little bit, we need to have foster parents have a seat at the table and be able to present more information to the court so the judge can make an informed decision. And I will just add a little bit of more anecdote here. Over the course of the last few weeks, I spent 2 full work days attending legal proceedings as my children's case has become increasingly complicated. During these 2 days, I only witnessed about 15 minutes of the discussion. Because I'm not a party to the case, I have no right to be represented in these discussions, which only involved the attorneys. So I'm missing a lot of things. When I do see things, as I said, the case is very complicated at this point, and the judge and attorneys seem to sometimes struggle with some of the details, some of which I think are pertinent to the case. So again, just having the foster parent present, I think would add additional information and help the judge to make the best decision possible. Thank you again for your time.
Thank you very much. William Blevins, please.
Good afternoon, committee. Good afternoon, Delegate Grammer. Good to see you again. Thanks for having me. I am the president of the Baltimore City Resource Parent Association. Hopefully you'll vote favorably for this bill. I had a nice prepared statement, but I just want to hit some points. Delegate Griffith, we've had a child 20 months in our care, had 4 workers so far. 4 workers. In 2 years, we have had 3 workers for our home. 1 child that left our care, we provided a binder, 3-ring binder, maybe a 3-inch one. And the worker made the comment, wow, that's more information than I have. And that worker had actually stayed with that child. The workers are overworked. They're doing the work of 2 to 3 workers in Baltimore City. And again, everybody's emphasizing, we just want to give information. We want to be there to give information. When we don't think that information, if I have a good relationship with the worker, with the attorneys, and they will take the information, they're asking for the information, there's no reason for us to step in. There's no reason for us to become a party to do that extra work. So we won't. We don't need to. They have the information. But this allows us that if we don't think the information is getting through, that we can become a party to give the information to the court to make the decision. In our case, we had a child the day before we were actually going to go to court to change the permanency plan. The department called us and said, please bring the child to court. We're going to send him next of kin. We went to court. We didn't think that was the best choice for the child. Waited 4 hours at the courthouse. We were asked to come into the courthouse. They asked us, are you related to the child? We said no. He said, thank you for your time. And we left and then went with kin placement. So this bill in no way will change that aspect of permanency going first to family, biological, next of kin, and then other resource parent, then other. It doesn't change that. It just allows us to give more information. So please vote favorably for this bill. It is needed. Thank you.
Thank you very much. Maheen Taqui.
Hi, everyone. Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Maheen Taqui, and I'm a foster parent in Baltimore City, and I fully support House Bill 893. My background is in international youth development, and my husband's background is in immigration law. I would like to share with you my family's unique experience as a foster family and why I believe this is so important to us. In late September 2019, I gave birth to our daughter, Amala, and 3 weeks later, we were placed with a beautiful foster baby who was just 6 months old. We call him Sai. Sai had suffered significant head trauma, and the doctors were uncertain of his recovery. We had picked him up from the PICU at Hopkins, and in those early days, we were making 2 to 3 trips a week to doctors and therapists, bringing along Amala and our older son, On. Even though Amala and Sai are 5 months apart, to us, they are our twins. We treat them like twins to our family and friends. And whatever we do for one, we do for the other. They are the best of friends in our world. Sai has now been with us exactly 18 months today. And in those 18 months, he has made phenomenal progress. The doctors thought he wouldn't be able to talk or walk, and he's proving everyone wrong. He is not only meeting all his milestones, but exceeding them. And he turns 2 on Saturday. As parents, we want nothing more to love, cherish, and protect our children. And my husband and I strive to do this every day. I say strive because For Sai, I find myself coming short. I cannot protect him like I can my other two children. I cannot advocate for him. I cannot attest to his development. I cannot speak for him. And this is what keeps me up at night. We are solely reliant on our attorney and our social worker to advocate for him, and that's not fair. We are lucky to have a good attorney and a social worker, and I know other families are not as fortunate, but still, it is not enough. We as foster parents should be able to be a party of our children's case. We should be able to come into the courtroom, hold our child's hand, and give them comfort. For Sai, he's the only parents right now that he knows, and for us not to be there with him just breaks my heart.
Ms. Taki, if you would please begin to wrap up your remarks, we appreciate it.
Sure. It's been 18 months since Sai has been part of our family, and yesterday was the first day his case was actually heard for the first time. If it was not for a lawyer, I would have not known anything, what was happening, when it was scheduled, and she was only able to share just the minimum details. And ultimately, my family and I are left in the dark, not knowing what's going to happen. Being a foster parent, as the others have said, is the most amazing experience. Being able to open up your home and your heart to a child who needs a safe and nurturing place is something that I just cannot express. All the foster parents I know feel the same way in this journey. We are giving all our love, everything that we can. And we just ask that you see our work and help us advocate for our children in our care. So thank you.
Thank you very much. Joy Booth, please.
Hi, delegates. Thank you, Mr. Chairman, Madam Vice Chair. I thank you for this time. I've been a foster parent for 7 years. My husband and I have adopted 3 children from foster care, and I am the president of our local foster care association. I am here because I'm frustrated with a broken system, and I've attached in written testimony lots of experiences from just my own family of the different scenarios where this law would be beneficial. But not only for me, I've heard it from multiple foster families. Every time we talk with other foster families, there's issues of a system that isn't working as smoothly as it should. This law is about making sure that the judges have all of the information. Delegate Griffith asked about how many times the caseworkers turn over. Well, even if you have the same primary caseworker, there's still lots of different people within DSS that may have bits and pieces of information about a child, but no one seems to have the big picture. There was one week I had 15 different people that I spoke to about 2 different foster children that were in my home. As foster parents, we're the clearinghouse of not just the people at DSS, but also the doctors and therapists and all that. We have that information. We want to see that the judges have that information. Colorado has a very similar law to this on their books, and there is a Supreme Court case that is in the written testimony that addresses whether a birth parent's due process is impinged upon by having foster parents intervene in the court case, to Delegate Cox's comments. And in summary of the Supreme Court case was that the judges benefited from the extra information and it did not impinge on the due process rights of the birth parents. People have said, well, why can't you just have that right to be heard? I've been at many, over 24 court appearances with my kids, and I've gone in, made a statement, and then been asked to leave. And many times I was asked to leave by the birth parent attorney. And what I found out was that in the court cases, that the birth parent's attorney was trying to use things that had happened in my home or whatever as reasons that to defend the birth parent. And it caused a division between the birth parent and myself. I know that there were some allegations that, well, this is going to cause a division between the birth parent and the foster parents. I think in court, that's generally going to happen in some form or fashion, but I worked hard with the birth families to try and if the birth family is healthy, that's going to benefit these kids that I love. And we want to see the benefit of the kids that we love. But their traumas that have happened in the birth family do affect our kids. There was one instance, I had a 4-year-old who actually ended up adopting.
Ms. Booth, we'll need you to wrap up your testimony.
I'm sorry. I have lots more to say, but I will just say this. DSS has a real problem with keeping foster parents, and they brush aside foster parents and our legitimate concerns about the children's well-being. We want the judges to decide. Let the judges hear all of the information, and that's what this bill is about. Thank you.
Thank you very much. Just as a note to the parents, I don't mean to be disrespectful, and all of you have stories that are speaking to to people and to children to whom you feel very strongly about. I am just trying to keep us.
Understand.
We were here till midnight last night, and we're hanging in there right now, and we want to hear this and hear all of these stories today. Okay, I don't believe Michelle Wolf is in the waiting room, and that was what I got from staff. So we will take questions for this panel, and then we'll go to the next one. So are there questions? Delegate Griffith has the first.
Thank you, Mr. Chairman, and I want to be respectful of the committee's time, and maybe Delegate Dumais, you could maybe be helpful on which parent should answer this question. I'd like to keep it to maybe one parent, but it's certainly reasonable that foster parents would bond with their foster kids. I think it's difficult not to. But when foster parents and we already have a 50% churn rate in foster parents in the state of Maryland for a variety of reasons. And if any of the foster parents could attest to this with your experience and your experience with other foster parents, are we finding that some of these experiences where you're not properly able to advocate for the foster children has caused foster parents to leave the system?
Delegate Griffith, that is absolutely the case. As I'm also a member of the Maryland Resource Parent Association, and we have addressed that. We see that all the time with foster parents coming forward and saying, I'm frustrated. I love my kids. I love the care that they've gotten, but I can't handle the frustration in the system any longer. So this child is the last child we'll take care of, and we are going to close our homes. That happens all the time. In fact, I believe that there was from the federal government, Maryland was tasked with involving foster parents more in the decision-making process. I sat on a committee at the state level and was extremely frustrated. I felt like I was a box being checked. Check, we've got a foster parent, but the concerns that I was bringing forward were not being heard. And like I said, I know I could list lots of names of foster parents who are frustrated by the lack of responsiveness to concerns from DSS.
May I say something quickly? My wife and I are first-time foster parents, and after whatever happens with our current placement, our current child, we're not sure that we'll continue to be foster parents if the system remains as is. It's emotionally draining. It's taken over our lives, affected our ability to get our work done without having a chance to have equal access to information and advocate for the child that we take care of all day. I'm not sure we'll continue unless really big changes are made.
Are there further questions for this panel? All right, seeing none, we thank you all very much for your time here this afternoon. We'll go to the next panel. Lauren Dooley, Ingrid Burford, Brian Zubek, Arnold Ebby, Ryan Howard, Tamira Dunn, and then I'm going to call two more because we believe that there are two of those people who are not in the room. Danielle Meister and Marcy Krawczyk. Right, if we could start, please, if Lauren Dooley, there is Lauren Dooley. Lauren Dooley, if you would please speak for 2 minutes, we appreciate it.
Thank you. Hello, everyone, especially Delegate Griffith, Delegate Erikins, and Delegate Cox, who we all spoke with last year. My colleagues Joy and Andrew and I came up and we spoke to you regarding this bill last year. I hope you remember us. Let me explain what happens in court from a foster parent's perspective. First, despite the Foster Parent Bill of Rights, which is in Comar, which states that we have the right to be present at all meetings and court hearings concerning the children in our care, foster parents are often discouraged from coming to court and even kicked out without the opportunity to speak. In my work on this, I've spoken to foster parents all over the state, and unfortunately, the majority are not allowed to speak, even though that is our current right. We are not allowed to know what information is being given in reports and documents that are submitted by the other parties to the case, such as DSS, the bio parents' attorneys, or the child's attorney. We are unable to refute inaccurate statements because we don't know what's in those reports. My foster son's case was heard last week. The bio mom's attorney made several incorrect statements. I was very lucky that I was allowed to speak, and I was allowed to speak after her so that I could correct the inconsistencies. Had I been discouraged from attending or kicked out, I am absolutely certain the judge's decision would have been very different from the ruling that he made. I am blessed and lucky that I was able to speak last week, and unfortunately my situation is rare when it should be the norm. I also want to talk about some of the comments that were made about foster parents. People tell us all the time, you have to be very special to be a foster parent, and we usually brush that off because all we think that we do is we love these kids, but there is something to it. As discussed previously, the stipend doesn't cover expenses. You can't feed, clothe, and provide shelter for a child on $700 a month. Unless you are some amazing coupon clipper, it's not going to happen. We're not doing it for that reason. And we're not here to take every child away from their parents. Absolutely not. We know, because we're trained, we go through a very rigorous training, we go through background checks, and we have to submit financial documents proving that even without the stipend, we can still care for these children and provide.
Ms. Dooley,
Yes, sir.
if you begin to wrap up, I'd appreciate it.
Absolutely. In summary, I do have plenty of examples if you wish to ask me questions. And I also did submit written testimony, which I include as examples of reunification efforts that should have happened sooner or in a better way that foster parents could have helped with. I thank you all for your time, and I ask for a favorable review of this bill.
Thank you very much. We'll go now to Ingrid Burford, please. Ingrid Burford.
Can everyone hear me? Good.
Oh, there you are. That's great. We'll start 2 minutes, please.
Thank you so much. Good afternoon to the chair, Madam Vice Chair, and committee members. This is my first time testifying before any committee. So on behalf of myself and some of my close friends who are also foster parents in the state of Maryland, I do appreciate the opportunity to express support for House Bill 893, which allows foster, pre-adoptive, and kinship parents to have a seat at the table in court. I'm a current constituent of yours in Bowie, Maryland, and I have been a foster parent in Prince George's County, Maryland since December of 2018. Since then, via various processes, I've quickly become accustomed to the many inefficiencies in the processes governing fostering a child. So today I'm here to at least address one, which I'm passionate about, which is being a part of this court process. Being a part of this process, it's really important to me, particularly because every day I currently think about a 13-year-old who was sent home because her biological mom was able to show that she cleaned up her home and provided a separate bed for her. Yet based on information that was given to me and the child and her siblings for whom I also had, she was sent home to live with her molesters and sex abusers. Since being sent home, a myriad of issues ensued: school suspensions, fighting teachers, depression, the list goes on. All because I, as a foster parent, was not really allowed to participate in the hearing to be able to adequately ensure pertinent information that was brought up to me be weighed in the decision made about the child. Mind you, much of this information are in case files from even previous incidences that caseworkers do not read, attorneys do not read. So no one can present this to a judge or magistrate making these decisions. To make matters worse, caseworkers get changed often, making the critical nature of the information get lost even more. I've been removed from hearings, told that I cannot sit in, where information's been stated about me that no one at the hearing refutes. Information about the children are presented that are incorrect, that I could have assisted, and information presented that had I known about the children, I could have done things differently for the care of the child in my home. Critical information that I have provided to social workers and the kids' attorneys, they don't often come up in court, that I think it's pretty relevant to any decisions made.
Ms. Burford, if you would begin to wrap up, I'd appreciate it, please.
Certainly. So currently, I strongly support this bill for these and a myriad of other reasons stated here today. And I hope that the decision is favorable from the report committee on this HB 893. Thank you.
All right, thank you very much. We'll go to Brian Zubek, please. Oh, wait a minute. I'm not sure that Brian Zubek is in the waiting room. No Brian Zubek. Okay, Arnold Eby. And if I mispronounced your last name, I apologize.
Thank you, Mr. Chair. My name is Arnold Eby, so you were close. But anyway, thank you for hearing us today. I am the Executive Director for the Maryland Resource Parent Association, but more importantly, my wife and I have been foster parents for 20 years. I do not think that this bill will solve every problem, but I think it's a step in the right direction. I think it's something that's necessary. I believe that it also gives an incredible opportunity for a resource parent who has built a relationship with a biological parent to advocate for for reunification that would be in the best interest of the child, for services that will help that reunification to be successful. So I think it's a great way to provide information that makes the final outcomes for the child successful. Thank you very much for your time. I request that you think favorably about this bill. Thank you.
Thank you very much. We'll go now to Rian Howard, and we'll ask you to speak for 2 minutes.
Hi, it's Ryan Howard.
Can't win for playing today. Okay, Ryan Howard, sorry.
It happens all the time. My husband and I have been foster parents with the Baltimore City Department of Social Services for 3.5 years now. We very shortly after being licensed, received a call for a placement for a 3-week-old drug-exposed infant and his sister, who at that time was 7 years old. They've since been in our home, and we are hopefully weeks away from the adoption being finalized. This has been a road, and not an easy one. A lot of the information that we got, we've had to sort of discover over the 3.5 years. We recently found out that my daughter, who's been struggling and not knowing why, that she was drug exposed as well. And it wasn't until we started signing the adoption paperwork that we found out that she had been drug exposed. And had we been able to attend some of the earlier court dates after they'd been in our home for 15 months, I think that information would have come out and would have allowed her to provide a different level of care. It certainly explains a lot of behaviors now. And even today, after she's realized that the adoption is finalized, we're still having behaviors that have not been able to be resolved, and we're still trying to figure out how to resolve them. But very early on, I had asked what the permanency plan was. This was after 15 months of them being in our home, coming to find out that the clock had not yet even started of them being in our home. because they were not yet committed to care. And while this was before the 12 months, had I been allowed to go to those earlier court dates, I would have understood that. And we would have been able to work with the biological parents in a very different way than what we had been. We had, in the earlier months, we had received telephone calls from the biological mother. We had visits with the biological mother one time, and she was about 15 minutes late to that visit. And that was all of the contact that we had had up until the point that parental rights were being terminated. And it wasn't until I got ready to testify that I was—
Ms. Howard, I'm going to need you to begin to wrap up, please.
Will do. It wasn't until the TPR started and that I was put on the stand to be able to testify to all of the things that we had experienced over this 3.5 years, what would happen after telephone calls with my daughter, the nightmares that my son began to have after he was required to have visits with people that he didn't know. This has been a really long road and a difficult process, but had we as foster parents been able to be a party to the case earlier on, I think we wouldn't have been 3.5 years into this process before my daughter finally got to change her last name to Howard, which she's been doing for 2.5 years at school.
Ms. Howard, I need you to finish up there. Thank
So
you very, very much.
I'm asking the committee to please look at this bill favorably.
Right, thank you very much. We'll hear from Danielle Meister.
Hi, good afternoon. My name is Danielle Meister, and my husband was here, but had to go attend to our toddler who can wait for no Zoom. So we are here to testify in support of the bill today. We have been foster parents to a 3.5-year-old boy since he was 11 months old, so going on 3 years almost. And we are very close with his teenage sister, who, while not in our care, is in a residential facility, and we maintain really close contact with. So we see her, as a quasi-daughter, even though she's not with us full time. But we're testifying today because over the course of the last 3 years, we've had 3 different caseworkers. We're now going on to our 3rd. We have been lucky, like many others, to have a great guardian ad litem. But again, to just underscore what you've heard already so far, these folks, while well-intentioned and trying their very hardest at their jobs, spend a minimal amount of time with the children that are in our care. We are their primary caregivers, their primary advocates, and we are intimately involved in every aspect of our foster son's life, whether it's his social, emotional, or physical health needs. We also, I think something that I haven't heard, but I know is happening from the friends we have that are foster parents as well, is over the last couple of years, we have increasingly become, as foster parents, the sole folks to facilitate visitations, whether that's in person or on the phone with the biological family, with siblings that are also in care. And so more than anyone who is a party to the case, we actually have those day-to-day interactions with all of the people involved. We know much more about the biological families than DSS does. I'm in much more regular contact with the parents of my foster son than our caseworker is. And we've had really specific examples over the last 2.5 years of not only being invited to court hearings to be witnesses, and it's only happened 3 times over the course of 2.5 years. Each of those times we were not allowed to hear the testimony of anyone else who was a party to the case. We have never been a part of a discussion about the service plan for the family or the plan for reunification. And more importantly, we've learned after court hearings that inaccurate or incomplete information has been given by all parties to the judge who's making these really critical, life-changing decisions for these kids in care. And so some specific examples are things like the parent's attorney asserting that they had not been given visitation when we had gotten— I'll keep it short.
Okay.
Yes. So, knowing that we facilitate visitation and have records of that, and there was assertion that it wasn't happening, all the way to DSS not having the phone or address of the biological parents to do their casework, and we had to provide that. So I just want to underscore that foster families are at the center of a lot of this work, but we are the most removed from the actual process and decision making. So I just urge you to find a favorable report for this, and thank you for allowing us to testify today.
That's fine, thank you. I'm going to ask, I know that Marcy is in the room. If we could go ahead and bring in Jacqueline Hardwick, Monica Brame, and Tawny Epperson, all three of them, that'll complete the list of people who have signed up to testify in favor, and I think that'll help make this a little more efficient. With no offense to anybody, it's just probably, I think it's good for us to hear all of these stories kind of all at once here and then ask questions. All right, Marcy Krawczyk.
Hi, my name is Marcy Krawczyk. I have been a resource parent with Baltimore County for 5 years, and I am in full support of this. My current foster daughter was placed with me over 2 years ago after 3 weeks of withdrawing from cocaine in the NICU, and her baby sister is there now doing the same. Mom has had a total of roughly 3 hours worth of visits in this time, and yet almost 26 months later, this little girl is still in foster care. I would adopt her tomorrow if I could. I am the only mom she has ever known. She is stable, happy, healthy, and loved, and yet at any moment, that could all get ripped away from her. I have attended every review hearing, not only for my current foster daughter, but my previous one as well, who was with me for 2.5 years. I have had to sit back and listen to false evidence being presented and wishing I had the right to speak up and advocate for my girls. In our current case, my foster daughter continues to hang in the balance and waver in uncertainty because of decisions made in court. I would have loved to have the opportunity to advocate for her. I believe it would have made a difference to be able to share in detail how hysterical my first foster daughter would become when a visit was mentioned with her mom, and how she would tell me about her getting hit. I believe it would make a difference to be able to correct misinformation. I believe it would make a difference for foster parents, the ones who know the children better than anyone else, interact with their teachers, take them to the doctor, and tend to their medical needs, provide comfort when visits cause anguish, to be given a voice. This is why I urge you to support this bill. Thank you.
Jacqueline Hardwick, please.
Hi, good afternoon. My name is Jacqueline Hardwick. I am a current single foster parent from Baltimore City. I'm here in support of House Bill 893. I have a 13-month-old baby boy in my care. He first came into my home at 4 days old. I met his parents at an unsupervised visit at a doctor's appointment that was set up by the caseworker. In hindsight, this was not safe nor appropriate. Both parents have since been in jail, and one of them is diagnosed with a significant mental health disorder. At 2 months old, he was placed with a relative, his biological mother, that the court system said could not care for him or be around him unsupervised, was living in that relative's home where he was placed. During the time he was placed with his relative, his biological mother asked me to take him over the weekends, and at one point stated that she and her son had been kicked out of the relative's home, and she asked to stay with me. Once again, she did not have any custody at this time and was only supposed to have supervised visits with her son. My foster son then came back into care and returned to my home at 4 months old. There was a new caseworker who I had to provide information to because they did not have it, and share all that had happened with me personally during the time that my foster son was with his relative. I fast forward now to his 4th caseworker in 13 months. And pending transition back to the same relatives who allowed my foster son to be put in harm's way. I feel that I could have assisted with putting the pieces of this case together if given the opportunity to be present in the courtroom. Out of all of the adults in this case, including DSS workers and his biological family members, I know my foster son and his journey the most. I have asked caseworkers and my foster son's lawyer questions throughout this entire process, and just recently did I find out that I can even make a statement at court. I am frustrated with the system, the processes, the communication, because at the crux of it all is an innocent child. This 13-month-old baby has been placed in foster care 2 times already. These early years are crucial in the development of the brain, and transitions and trauma greatly impact that development. If I can provide clarity in a courtroom regarding a child that is within my home, I would take that opportunity to share facts related to the case and keeping the child at the forefront of the conversation. Thank you so much for allowing me to speak.
Thank you very much. Monica Brame, please.
Good afternoon, everybody. This is my first time participating in a hearing, and it's been very interesting watching you all today. So I thank you all for all the work that you do. I think you've heard a lot of stories already, and I am a foster parent in Montgomery County. And I've been doing this for less than a year, so I actually wouldn't be included in this bill at this current point. However, just from my experience, I can tell this is something that is absolutely needed. We're being asked, children are put into our home and we're being asked to provide love and support. However, we're missing a huge piece. For the few placements that I've had over the past, I've had 2 placements in the past year. And for both of those, I always have felt like I'm missing some information. I'm never being invited to court. When I ask a question about why the child is being placed, it's very vague answers. It's very difficult to understand what support I specifically need to give to the children that are being placed in my care. And it just seems like that's as multiple people have said throughout the day, it's a break in the system and it's just not working the way it's set up here. Just from this experience today alone, you all have been able to ask lots of questions. You've been able to kind of get multiple sides, multiple aspects of the stories, and there's always going to be a bias in one direction or another. We're all human. However, you have the opportunity to get the information so that you can make the best decision that you all need to, that you can make. I mean, that's what you guys are in your roles to do. None of us are perfect, and I know that the system won't be perfect, but I think giving foster parents the opportunity to be able to hear multiple sides and not just a tidbit of a perspective is going to ultimately help the welfare of the children that are being placed in our care. And because of that, I support this bill 893. Thank you.
Tawny Epperson.
Good afternoon. Thank you for the opportunity to share. My name is Dr. Tawny Epperson. I am a current foster parent, and I'm here to respectfully request that you support this bill, not simply to bring equity to court proceedings, but to further the cause of permanency for children in the foster care system. We have 3 children in our care that have now been in the foster system for a cumulative 2,568 days. We have supported their birth parents and have a very positive relationship. We have been fully engaged in the court process to the extent we were permitted. However, time and time again, we have been forced to sit in court and remain silent as incorrect information was shared. We were never able to rebut this information or retain our own counsel as part of the proceedings later on. Instead, we watched as some of this faulty information contributed to the extension of the case well beyond the federally mandated standard. It is not in the children's best interest for foster parents to be marginalized in court. It does not follow reason that individuals with a wealth of day-to-day firsthand information should not be permitted to submit evidence. In our case, after caring for these children for years, we cannot submit anything to the court, while a worker, their third worker, by the way, who sees them for 20 minutes or less per month is permitted to file reports and make recommendations to the court on behalf of the children we are parenting. I implore you to put the rights and safety of children first by favorably supporting this bill and allowing courts to make permanency decisions based on a more comprehensive scope of information. And this can only be achieved by allowing foster parents to opt in as party to the case. Thank you so much for the opportunity to speak.
Right, thank you all very much. Are there questions for this panel? Seeing none, we thank you all very much, and that concludes the testimony for those in favor of House Bill 893. We'll now go to the opposition.
Mr. Chair, there's a comment in the chat. I don't know if you saw that or not, about someone in the waiting room.
Tamira Dunn is waiting. Could we please try and bring in Tamira Dunn, please? We don't see her name. She has to be signed up with her name in the Zoom so that we can see her. Understanding is that there are multiple names. None of them are Tamira Dunn. If we can figure it out, we will try and get her in after we now hear from the first of two of the opponents. We'll hear from Maria Villamar for 2 minutes. Or did we lose her? From the Office of the Public Defender?
Yes, good afternoon, Mr. Chair, Madam Vice Chairwoman, and members of the committee.
Could we please see your video?
Yes.
Video stream.
I was just cut off of Zoom and I had to.
There we go. All right. 2 minutes, please.
Yes, thank you for giving me this opportunity to testify. I'm so sorry. My internet connection is acting up. If you could just give me 1 second. There. I'm the chief of the Parental Defense Division of the Office of the Public Defender, and we represent the mothers and fathers whose children have been separated from them by the state, but who are working hard to try to reunify with them. One of our strongest objections to this bill is that it gives no discretion to the court to do what is right, what it believes is in the child's best interest. Blanket rules are just never a good idea when you're dealing with families with different backgrounds, different issues and problems, and different needs. Children and their families and foster care providers are not all the same. And so while in some cases it might be in the child's best interest for a foster care provider to be a party, in other cases, it would not be in the child's best interest. The problem with this bill is that it gives the court no discretion to make a decision that's best for that particular family. It's just a blanket statute, and it doesn't give the court the opportunity to say, no, it would be a bad idea in this case, or yes, it would be a good idea in that case. Most of the families involved in the foster care system are poor and underprivileged, and as we know, are disproportionately members of minority groups. Allowing foster care providers who are often wealthier and more educated and who are much more privileged in other ways further devalues the parents and their children's voices. It gives them an equal right in what should happen to the family. And this right to intervene does in fact change the playing field, because the foster parents are on the same level with the same opportunity to fight for custody of the children. And right now, that's not how the law views them. I'm not trying to devalue the role that foster parents play. Of course, they play a valuable role. But we have to look at this in the eyes of the law and in terms of how court proceedings go. Before my time is up, I would like to point out that the statutes already provide the right to intervene to foster parents. Courts and judicial proceedings gives them the right to notice and the right to speak. And under Maryland Rule 11-122, they have the right to apply for intervention and to get records that are pertinent to have custody of the child. I'm curious to know whether any of the foster parents who testified today have attempted to exercise this right to intervene and whether the court has denied them that right. I haven't heard anybody say that. But anyway, the law already provides them with this right. There's already a mechanism.
I have to ask you to wrap up, please.
There are a lot of problems with the foster care system. I will acknowledge that, but I don't believe that this is the solution to the problems that we're hearing. Thank you.
Thank you very much. Stephanie Franklin.
Good afternoon. I am the president and CEO of the Franklin Law Group. We provide legal representation to children in 6 counties across the state of Maryland, have been doing it for over 14 years, and I personally for over 22 years. And so I want to focus on a voice that I don't think is being heard very well here. We're talking about parents, we're talking about foster parents, but what we're not talking about is children and speaking for children. And one of the things that I think that this committee really needs to understand is that Maryland is a unique state. There's only a few of us in Pennsylvania and a few other states that has a legal structure set up where children who have considered judgment, meaning that they can make a reasoned decision, as to what they want the outcome of their case to be, versus a child who doesn't have considered judgment, cannot make a reasoned decision, and so the attorney is acting in the best interest. Those are two different things. I'm hearing a lot about guardian ad litem, but nobody's talking about the child with considered judgment. And so I want to say to you what many foster parents don't know, and where I think that your voice is very important. What they don't know is that sometimes, even though there's been a lot of testimony on the other side that attorneys for children only speak to them maybe a few minutes, 3 times a year, what they don't know is what's told to us during those conversations and in those interviews. And some of those children will say things that are contrary to what the foster parent is saying. And so having said that, passage of this bill will undermine the child's voice in this proceeding and also destroy what's called family integrity. And that is the maintenance of the parent-child relationship. There's been a lot spoken here today about how the foster parents are harmed and how the children are harmed from certain things. But one thing we need to keep in mind is that when foster parents sign up to be foster parents, they sign up just to be that. To be temporary, short-term caregivers for children, and that they are to act in the capacity of a mentor to the biological parent. As what was already stated, these families that come in are already in a compromised situation. And so most of the time, the children will tell you that they want to be with their with their parent.
Ms. Franklin,
so
if you would begin to wrap up, I would appreciate it.
As it was stated very earlier by one of my colleagues, is that foster parents already have the right to intervene. The notice issue is an issue that's an educational issue. It's a law on the book and it needs to be implemented. That's the systemic failure, is that they need to be educated and told that they have this right. In our particular law firm, all of our attorneys tell the individual foster parent that they have a right to be heard. So this is not the solution. I'm asking that this committee, I urge this committee to pass an unfavorable report for this. The law is already on the books. They have a right to be heard, and many courts will actually inquire.
Thank you very much, Ms. Franklin. Thank you very much. Are there questions for this panel? Delegate Cardin first.
Thank you very much, Mr. Chairman. Thank you both very much for coming in and testifying. Ms. Villamar, I am generally very supportive of the Office of the Public Defender, having worked there years and years ago for a brief period and understanding some of what you guys do. However, I found your testimony today not as persuasive as I would have thought. You spoke about wanting to give the judge discretion. However, you're also saying that you don't trust the judge to be able to hear testimony, perspectives from the foster parents and be able to figure out what is in the best interest of the child. And I'm wondering why I think that is cognitive dissonance, and I'd like you to respond to that, please.
I'm not saying that I don't trust the judge to be able to weed out the relevant evidence and the non-relevant evidence. What I'm saying is that if a judge believes that it would not be in the child's best interest to have another party involved in the mix, in which is a legal case, right? At the end of the day, we're all in court. It's a legal matter, and it may not necessarily be in the child's best interest to have another party coming in and fighting for custody of the child. For example, suppose the judge, children's attorney, DSS attorney, parents' attorneys all agree that the plan is reunification and that the parents and the children should now be reunified. Under this bill, a foster parent could come in and intervene as a party and oppose that and put the entire family through hearing. The court would have no choice but to say, we have to go through basically a custody proceeding, even though everybody is in agreement that this family should be reunified. Because after all, that is the goal of the juvenile statute. It's not like a custody statute. It's not like a custody hearing in family court. This is a custody hearing that's initiated by the government. It was the government that removed the child. And so the parents have a greater right to reunify with their family. But under this bill, the court would have no choice but to continue to have that hearing.
Right, but then the likelihood is that they're going to they've already come up with their decision, then they're probably not going to be persuaded by whatever testimony happens in that hearing that is required to happen.
So why should we strain resources any further if the court doesn't need to hear from the foster parents? Give the court the discretion.
What if there's new evidence that the court didn't know that may be persuasive?
Well, then the foster parents currently have the right to intervene. Under the current law, they have the right to intervene. They can file a motion and ask the court to make them a party in the case. They would have all of the rights that the other parties have, the right to have an attorney present with them, to present evidence, etc. There is there's nothing preventing them from exercising the current right. The only thing that we're asking is that the court have some discretion so that they can make a decision that's best for the child, that's best for the family, and that doesn't result in a waste of scarce resources that judicial resources, attorney resources, etc. I hope that answered your question satisfactorily.
Thank you very much. Appreciate it.
Delegate Griffith.
Thank you, Mr. Chair. And for Ms. Franklin, I will just say, as a former foster child myself, I will assure you my primary focus is what's best for the children. And I will also stand up for my honorable colleagues on this committee who are all committed to justice, who I guarantee all of their primary focus is what's best for these children. So I will push back on that some. My question is, one of the comments that you stated was, foster parents getting into this to be caretakers. At the same time, being critical of their ability to be involved in their lives and to intervene on these matters. So I guess my question is, if, we expect these foster parents not to take a parenting role, then why not remove the foster system altogether and just put all the foster kids like myself just into group homes?
But nobody's saying to remove the parenting role. That's not it. But when foster parents sign up, and it's clear on the COMAR, was it Title 702-2501B1? They are to be a short-term resource. Short-term, that's it. Now, there are some that may be an adoptive placement, and if they're an adoptive placement, then they are probably getting kids, down the line who will be adopted. But you can't undergird the family that way. Family integrity is important.
I was in one foster home for 6 years. Pardon me. I was in one foster home for 6 years myself and never adopted.
And that's your individual case.
Mm-hmm.
But that's not everyone's case.
Sure.
And so we have to look at this individually. Right now, the laws are on the books. What is it? Courts and Judicial Proceedings 3-816, point 3C allows a foster parent to be heard. The bench themselves will ask, is the foster parent here and want to be heard? So this is a matter of not expanding this statute or passing another law that isn't on the books. How many laws do we have on the books that are not being implemented? This is one that possibly in some of these jurisdictions are not being implemented effectively. But I would argue, because I've done this for a very long time, my firm has done this for a very long time, and we are in a number of jurisdictions and the larger ones to boot, is that this is something that the court routinely asks of foster parents. And it was stated earlier, the foster parents already have this right for a motion to intervene. They can file it. And it's also been my experience that the courts will actually weigh more in favor of what the foster parents want than actually the parents. So I think expanding their rights and giving them any more access is a problem. I will also say this. I do recognize that sometimes foster parents are not receiving all of the records that they're supposed to receive. That's a systemic issue. That is a systemic issue that I don't think needs to be resolved through the expansion of law, but through the implementation of the laws on the books. The department has a requirement by policy to create a case plan for the family. in that case plan, there also are supposed to be records like the healthcare passports that transfer from family to family so that each foster parent that may have this child or may receive this child has the relevant information. Now, sometimes the department doesn't have all that information to begin with. And I think that's where the focus needs to be, not expanding more laws, but implementing what is already on the books.
Well, ma'am, I just will say, I don't think my foster parents would mind me saying this because I'm pretty sure we're outside the statute of limitations at my advanced age. But I will say, if not for my foster parents intervening, I would not be here before you today. So thank you very much for your comments.
Delegate Grammer.
Thank you, Mr. Chair. One question for Ms. Villamar. Couldn't it be said that in these cases, if you have a foster parent who has information that, you know, these parties that are prejudicating these decisions, and, you know, the foster parent's working with the child, the foster parent believes they have information that other parties haven't interviewed, and if you're predetermining decisions and not allowing foster parents access to these hearings, that you're, in some cases, at least in some small way, you're not really, you're cutting out some of the information that, as a matter of truth, you know, that's has the best interest of the child at heart. Can you speak to that, please?
Yes. So when I said that a court may have already made up its mind, I'm not saying that it should do that. The court really needs to have a hearing and to gather all of the information before it reaches its decision. If the foster parents have information that they think the court needs to have in order to make the right decision, the foster parent can offer that because they have the right to receive notice of a hearing and they have the right to speak up at the hearing. There's nothing preventing them from offering up this information that they have. There are also other avenues for providing the information, I should add. They can ask one of the other parties to call them as a witness. They can move to intervene, as I already said. They can write a letter to the court. They can write a letter to the social worker. They can notify the other parties. Believe me, I've been doing this for almost 25 years. If there's information that's going to help one side or the other win, they will provide that information to the court. So if a foster parent contacts me as a parent's attorney and says, I have this information that I think will help your client to attain reunification, I will present that information to the court and I will bring the foster parent in to testify. And I know that Stephanie Franklin and the other children's representatives and attorneys would also do the same thing, and so would the Department of Social Services. It's not a matter of trying to suppress information that the foster parents have. It's just a matter of how we get that information to the court. And I firmly believe that expanding the right to be a party in this case is not the right way to go about doing that. It will create more problems than it will solve. Thank you.
One quick follow-up. We've heard today where we've had, court's not perfect. We've heard today we've had cases of judges not even following the law. If you have a process where you can submit information, is it ever going to live up to the ability of someone to attend in person and make their case heard? I mean, there's a reason I believe, and I appreciate your professional experience. I think you certainly know more about it than people like me. But isn't there a reason that these families are coming to us from all over the state saying, we do have information that's falling through the cracks. We do have situations in which we felt that we haven't been heard. And in cases, there are circumstances where if the process was changed, we believe that the information we have would have had a different outcome.
Delia Grammer, I appreciate your question. And I do acknowledge that obviously the court system is not perfect, if only that were so. But I do wonder how many foster parents have actually utilized the existing rule that allows them to intervene. It's just a matter of filing a motion. And if it's denied, they actually have the right to appeal that. So the mechanism is already there in place. I am curious to know how many cases exist in which foster parents filed a motion to intervene and were denied that opportunity to participate in the case.
Okay, I appreciate your answers. Thank you.
Delegate Anderson.
Yeah, thanks, Mr. Chairman. I have been listening to this debate for a while. I was kind of impressed with Ms. Franklin's passion on this issue, knowing how these cases are so heart-wrenching and in many times drawn out for years. And just to ask her one simple question, and that is, you have opposition to the bill. I understand that. And I've known you for a long time. So I appreciate your understanding of this issue. If there were, give me a specific case or something that you've been involved with where this bill would be harmful to the best interests of the child.
Of course, I can't name case names, but I can tell you several cases where
just ones.
Okay,
yeah,
when you have children that are of certain age who will come to or speak with their attorney in private and will say, I don't want to be at that foster home. They make me do X, they make me do Y, they make me do Z. I really want to be back with my parent, but I don't want to hurt my foster parents' feelings. They cared about me, they've done well by me, but I want to reunite with my parent or parents. And they're very clear about it. And the fear that I have is that through all of this, these are children. So their articulation of certain issues are not at the same level as some of the adults, whether they're foster parents or the parents. And so in this, the court hears this. And again, it's been my experience that the courts actually weigh in favor of the foster parents. And my colleague, Ms. Villamar, stated earlier, these are people who generally may be more educated, right? Who may be more adept at navigating the system and speaking in court. Court is an intimidating and frightening experience for families, particularly families who are marginalized. It's a real issue. And so to give foster parents further access in ways that they already have just seems nonsensical to me. You are actually undermining the parent's rights. You're putting the foster parent on parity in terms of their due process rights as a parent, and that just shouldn't be so. Presumptively, it's always, even within the first 10 months, the permanency planning hearing, when we get to the permanency plan, that's usually 10 months after the child has been removed. Presumptively, it's always reunification, because bottom line, whether we like what the parents did or not, they gave birth to this child. And so giving birth to this child does not allow another party who did not give birth, and who also, I have to say this, and we got to be full-throated and very honest here. Every foster parent isn't like all of you on the panel. And some of them have very different intentions. Some of them come in that system specifically with the eye towards, I can't have a child maybe, and I want this child for my own. And I'll give you an example of that. There was a young child that was born drug exposed. So this is a child that doesn't have considered judgment, nonverbal. And he was placed with a foster parent immediately. And within, wasn't even 2 months. And this foster parent is saying, they're getting ready to take him away and they're going to reunify him with his father. I said, yeah, and I was one of the advocates that did that. This is not your child. You didn't birth this child. There's something called parental bonding, right? And the ability for parents to raise their own children. Who is a foster parent to come in and do that, particularly when they signed up to be short-term? Now, down the line, the court says, hey, this isn't in the best interest of this child, then so be it. It may not be in the best interest of the child. And quite frankly, it's possibly that children's advocates may stand with the foster parents. But to expand their rights to something they already have access to, that's clearly on the books, I think is problematic on so many levels, and is a drastic overreach. And it clearly undermines family integrity. And families are the cornerstone of this country.
Bottom line is, you kind of think that this bill would would step up a foster parent or a kinship parent above the level that they are now, and probably give them greater leverage over the actual parent.
Absolutely. You hit that dead on point. Thank you, Delegate Anderson.
All right, thank you.
I think it's also important to recognize the disparate impact that this is going to have on children who are in the foster care system. And as Ms. Franklin said, let's just be honest about this. Most foster parents obviously are wealthier, are more educated, are more privileged, and we're going to be pitting them against parents who, by the nature of the case, are marginalized, poor, uneducated. How is that going to, how is that fair? How does that bring justice to these proceedings? I think it does not. And I think that it's going to be a problem.
Okay, we'll go now to Delegate Erican, then Delegate McComas.
Thank you, Mr. Chairman. One of the things that Ms. Franklin had mentioned about how the children will tell her things that they may not want to say in front of the foster parent, just struck me. So I'm trying to imagine what the court case would look like now. There would be no opportunity for the child to feel comfortable telling you that if they knew you were going to go and tell the foster parent. Is that accurate how this would be? Is that how that would play out if we change this law?
Delegate Erican, you hit that one on point. Their voice would be muted. It would be silenced. It would prevent them from telling us things because they think we're going to tell. It also puts child's counsel in a very difficult situation because one of the things that we have to do is we also have to maintain relationships with these foster parents because we have to go out and visit the children in their placement. Right? And sometimes when foster parents feel that we're working in their mind in opposition to them, having access to the child, gaining all the information to the child is a problem, which then actually compromises our representation of our very client, the child.
Yeah. All right. Thank you very much. I appreciate it.
If I could add to that, Delegate Erican, it also places, yes, it also places the parents in a very terrible position because the parents are often very grateful for what the foster parents are doing. They don't want to have to go to court and fight against the foster parents. It jeopardizes their relationship as well, which will adversely affect the children.
Yeah, that's a chilling effect. Thank you very much.
Delegate McComas.
Thank you, Mr. Chair. I just want to ask Ms. Franklin this. Since you've been doing this for a long time, have you found that foster children don't necessarily go with the same racial background to the foster parents that they came from?
Sometimes, yes. Okay.
And so I would assume that the longer that child stays in with a white, I'm going to just say white family, they're going to kind of lose some of their heritage and their racial background. And I think I forget how you phrased it, but their heritage, okay, and their culture. And I know everybody at my age, everybody's kind of interested in their heritage and doing, ancestry.com and all kinds of things. And so I guess that's kind of another point of this, isn't it? That in other words, there's not a big enough pool of foster parents that, we might not have enough Korean parents to take Korean children, foster parents, enough Hispanic for Hispanic children, enough Black to take Black children. So it gets all kind of very complicated at that point.
You're absolutely right. It gets very complicated. And there are a number of children who may go with whatever, a different race, whether it's a Black child, Latinx, white, a number of them. And so, the erosion of the cultural identity and lineage and is really critical. The other piece is that there have been children who have been Black children who have been placed in Caucasian homes that have really complained to me about the cultural differences, cultural meaning just the way families interact, the foods that they eat. I mean, there was a child that was 5 years old that really suffered because she was placed temporarily with a white family. And it was really problematic for her. And she told me that. And then there have been older children who have told me that. And so the thought of having that type of leverage and separating that child from his or her or they, their culture, identity, it is a real issue. So I'm glad that you asked that question of me, Delegate McCombs. Thank you.
Thank you for answering that. Thank you.
Thank you very much. Seeing no further questions, we thank you both very much. We had some indication that Tamira Dunn was in the waiting room. There's no one named Tamira Dunn in the waiting room. And the person who is still in the waiting room is not responding to staff requests for information. So at this point, I'm going to end the hearing on House Bill 893. Thank you all very much for speaking with us today. If there's further information that people would like the committee to have, I am certain that it can be provided in writing, and I know that we will look at it if that information comes. So with that, that concludes the hearings for the House Judiciary Committee for today, February the 18th. We have the Public Safety Subcommittee meeting tomorrow at 11:30. We have the vote session tomorrow at 2 p.m. With that, we thank you all very much and